go. Good morning, everyone. Welcome to the first day of our oral argument session here in Philadelphia for the fall season. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated our court's historic 300th anniversary here in Philadelphia. Just by way of background, in its earliest years, the court actually convened in private residences, while the lower courts met in ale houses. In 1707, the city of Philadelphia constructed the townhouse, a two-story house and market, which functioned as an early city hall. The court conducted its business at the townhouse until 1743, when it moved to its own courtroom in the State House, now Independence Hall. Construction on this building began in 1871 and took 30 years to complete, longer than the Great Pyramid in Egypt. It was designed in the French Second Empire style by John MacArthur Jr. and Thomas Ustick Walter. For nearly 15 years, City Hall stood as the tallest habitable building in the world. Sitting atop our building is a bronze statue of William Penn, standing 37 feet tall and weighing 27 tons. Mr. Penn's statue faces northeast and points to a spot where he signed the Treaty of Friendship with the local Native Americans in 1682. Interestingly, this building would not exist if it had not been for this court. The Public Buildings Commission was established by the state legislature and tasked with the planning and construction of municipal buildings, including City Hall. Throughout the construction of the building, this court resolved issues with respect to funding, displacement of property already on site, and even the constitutionality of the commission itself. City Hall has 700 rooms, which house functioning offices for all three branches of government. This court became the first tenant in this building on January 1st, 1877. After the official opening, reporters deemed this to be the most handsome courtroom in the country and concluded that some of the more fastidious lawyers will hereafter take only Supreme Court cases in order that they may practice in this court palace. So with that background, and before we begin our arguments, I'd like to introduce some students that are visiting the court this morning from Temple Law School's Moot Court competition team, who are here with their professor and team director, Marion Braccia, and their appellate advocacy adjunct professor, Brandon Albaugh. The students' visit was arranged by Justice Dougherty's chambers, and I thank him for that. And would the students and their professors please stand? Welcome. We're really happy to have you. We hope that your legal careers are getting off to a good start and that nothing that's said here today will dissuade you from pursuing a career in law. Thanks for being here. Before we hear the first case, a couple points for counsel. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by stating your name and the party you represent and introducing your co-counsel, if any, to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of the facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. Please also remember that we do not allow rebuttal. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question, even if they're interrupting you. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we want to explore further. While there is no set time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. Good morning. Under Section 704A of Pennsylvania's Medical Marijuana Act, medical marijuana growers and processors shall contract with one or more independent laboratories to test the medical marijuana produced by them. The Department of Health, which has regulatory and enforcement authority over the growing, processing, sale, and use of medical marijuana in our Commonwealth, enacted a regulation known as the two-lab requirement, which requires an approved laboratory to test medical marijuana at harvest and a different lab to test the marijuana before it is offered for sale. In this appeal, we must determine whether the department was authorized under the Act to require the testing of medical marijuana by separate laboratories. Please proceed.
Good morning, Your Honors, and may it please the Court. Michael Fisher with the Office of General Counsel for the Department of Health. This case is about the Department of Health regulatory authority. And in looking to whether an agency has authority to promulgate a specific regulation, the analysis must always begin with where that authority comes from. Agencies do not have power to act unless the legislature gives them that power. We all agree on that point. Now, determining where that authority comes from requires looking at the enabling statute, assessing the scope of the authority. Did the legislature speak in narrow language, or did it speak in capacious terms? In addition, it's appropriate for the court to look at the stated purpose of the statute, where the legislator has set forth the purpose in the Act. I'm not talking about finding the spirit of the law or getting into anything that's off limits under the Statutory Construction Act, but where there's a stated purpose, that should inform this court's analysis of the scope of the agency's authority. So having done that, the next step is to ask whether the challenge regulation is within the scope of that authority as a whole. And then finally, the last step is to look to the statute and see if the General Assembly has in some way precluded the specific regulation at issue. Has it used clear terms to limit the department's authority so that they cannot implement this regulation? Now, applied here, the two-lab rule is lawful. First, in enacting the Medical Marijuana Act, the legislature spoke in very capacious terms. It said clearly the medical marijuana program shall be implemented and administered by the Department of Health. There are no other regulators involved, no federal regulators, no other state regulators. It's the Department of Health or it's nothing. They also gave the department regulatory and enforcement authority over the growing, processing, sale, and use of medical marijuana in this Commonwealth. Now, my friend has argued that that's actually a limitation. I think that really can't be supported within the confines of the statute. In fact, actually, it's quite a broad grant of, it's everything that happens with respect to medical marijuana, growing, processing, sale, and use. And finally, the medical marijuana gives or directs the department to promulgate all regulations necessary to carry out the provisions of this act. So given that very broad grant of authority, and particularly given that the legislature was clear throughout that the paramount goals of the program were, one, to protect patient safety, and two, to give patients access to potentially beneficial treatments.
Counsel, could I ask you, you've referred at least 3 times to the broader capacious authority. We're here specifically about 704A, and I'm unclear from what your remarks have been so far on whether it's your position that 704A is ambiguous or not. Is it ambiguous?
We have not argued that 704A is ambiguous.
Well, then, if it's not ambiguous, why do you keep talking about how broad and how capacious? Why don't we just begin at least with reading the actual words that the General Assembly passed into law? Wouldn't that be the place to start?
Yes, except that the department has not contended that its authority for the regulation comes from Section 704. That's the important point to make. It comes from the department's broad authority to regulate medical marijuana to protect patients' safety.
I think, I think we've all heard and certainly read in your briefs the word broad many times, broad, capacious, et cetera. But the first sentence says a grower processor, not the department, a grower processor shall contract with one or more independent laboratories to test. And I thought the issue in the case was, given that the statute says one or more, are you allowed to require that it be more than one?
Absolutely.
Isn't that the issue?
That is, I would say, the trickiest issue in the case.
Well, that's the issue. So I guess my question is, how is it, since the lawmakers wrote one or more, so it's a disjunction, right? One or more. If I have a tray of donuts, I say take one or more. Would it be your position that you're not allowed to take just one donut? You have to take more?
No, Your Honor, it wouldn't be. But
so how do you get the authority to require a minimum of two when the legislature said one or more?
Well, in Your Honor's scenario, that's a clear direction to the person being offered the donuts to make that choice. What's not clear in Section 704A is whether the legislature intended to give grower processors the exclusive right to make that decision, or whether the department could, in essence, make that for them.
Counsel, if I may. One of the arguments from the state is that you believe two labs were better for the public, to protect the public from contaminants.
Yes, sir.
And as you know, with the deference we have to give you is abuse of discretion. I'm somewhat concerned. Where's this public policy that the one processor or one lab can't confirm whether it has the same contaminants that you're alleged that a second facility must perform?
So one lab could do that. The department reached the conclusion that having two labs would be better and would ensure a check, as we say, a modest check on the process. The department was concerned, based in part on what it had seen in other states, that medical marijuana grower processors were developing close relationships with labs, and the result was, particularly with respect to efficacy levels, that results were being inflated.
So share with me why this court should not believe that logic is an arbitrary exercise of your regulatory duties.
Well, first of all, because we're not here on reasonableness review. That's the third prong of the test of any regulation. But my friend has not challenged the reasonableness of the regulation before this court. Commonwealth Court did not address that issue. We're here simply on whether this regulation is within the scope of the agency's authority. And second, the department was well within its discretion to conclude that having a modest check, which is to say, we're going to have another lab do the second test just to ensure that there's nothing kind of shady going on, just to ensure that the first lab, doesn't bend over backwards to keep your business or doesn't fudge the tests, or maybe just to make sure that, there isn't a methodological issue with the way the first lab does it that a second lab could see.
Was there any evidence to support that concern? Evidence, in the background of this industry that the one lab system wasn't working?
Well, the department reported that it had received numerous complaints from patients that the reported levels of THC in their medical marijuana was inflated. And that was what they were trying to address. And also, there were reports of issues in other states where there were, in some ways, I think, scandals with laboratories.
So you didn't come up with this out of whole cloth?
Well, we do not identify the issue out of whole cloth. I think perhaps the two-lab requirement was a novel way of resolving it, but it was...
Belt and suspenders, anyway. May I finish just a second? Was there also a concern about one lab monopolizing the market?
Yes, that's another issue. We have, according to the pleadings in the case, the lead petitioner represents 60% of the medical marijuana testing in Pennsylvania. And I think having a monopoly, particularly on something like testing, could be very dangerous because it could shut out other potential competitors. It could actually ultimately increase prices for medical marijuana grower processors. And also, stepping back a minute, it's important to remember, this is a program that was created only in 2016. This is the first comprehensive set of final recommendations, final regulations that the department had issued. So it's not the case that every single provision in those regulations needs to be a response to a specific problem that has been identified by the department. It's certainly possible for the department to try to get ahead of problems and say, okay, we're concerned that this could be an issue in the future, so we're going to act now and impose, again, a really modest requirement to see to it that there isn't a problem with it.
Nobody's saying that the reg is unreasonable. That's Tire Jockey 3. We're here on Tire Jockey 1. This we could stipulate this is reasonable. We could say that it would be best practice, that, boy, that darn legislature sure should have said what you wanted them to say. But we're here on Tire Jockey 1, and the law says one or more, and it really appears that the department just doesn't want to take no for an answer. I mean, why aren't you required to go back to the General Assembly and lobby them and tell them our experience is telling us, legislators, that you got to get rid of the one and you got to say more than, you got to change the law to more than one. I'm not satisfied that you're addressing Tire Jockey 1 as opposed to trying to show us that you're reasonable. We know you're reasonable.
Certainly, Your Honor. So first of all, under Tire Jockey 1, it's still necessary to look at the regulatory structure as a whole. So the question with respect to 704A is, within the broader structure of the Medical Marijuana Act, did the legislature intend that this provision gives grower processors the right, not the obligation, but the right to choose, I want to contract with only one testing laboratory?
I think you might have the test a little bit backwards. In Pennsylvania, at least as I understand Pennsylvania law, for an agency to have the authority must be conferred in clear and unmistakable language. You seem to be suggesting that for the grower processor to have the ability to make this choice, the General Assembly had to make it in clear and unmistakable language. I'm not aware of that being the test. I think Justice Weck's question to you is fairly straightforward, which is when the General Assembly said one or more, where is the clear and unmistakable delegation to the department to decide whether it is one or more than one?
So that is why I began the discussion with the broader regulatory authority.
But
that is where the authority comes from.
The broader regulatory authority, that is standard regulatory language that is given to agencies. I mean, you can take the language that you have in this statute and compare it to other statutes that say agency X shall promulgate regulations necessary and proper to carry out the enforcement of the act. It's a pretty boilerplate language. The question here is conflict. It's really a question of conflict. If the regulation conflicts with the statute, then the agency lacks the authority to promulgate it. Do you agree with that?
Absolutely.
Okay, so why isn't there a conflict here?
There isn't a conflict here because Section 704A does not make clear that it is the grower processor that has the sole right to choose whether to contract with one or more. A grower processor who complies with this regulation or who complies with the two-lab rule will contract with two labs and therefore will be in compliance with the statutory authority. We're not requiring grower processors to violate the statute. And on the broader picture, I think the two lead opinions in the Marcella Shell case sort of address this, that once you've established your broad authority, then what we need to look for is there specific evidence that the department or that the General Assembly intended to preclude the department from regulating in the way that it chose to? And here, I mean, 704, we can argue about what the legislature intended to do when it made the change to 704, but clearly it did not intend to limit the department's authority, because you had language in there that said A grower-processor shall contract with an independent laboratory, and they changed it to one or more independent laboratories. They did that knowing that the department was pushing this two-lab rule.
Well, and the language isn't necessarily inconsistent. One or more could encompass at least two.
Absolutely. I'm sorry, Your Honor.
Well, the Chief asked the same question I was thinking, which is if that's your argument, then why didn't the General Assembly just say two or more?
Well, the General Assembly, I think, could have spoken, the General Assembly could have been clear in either direction. If the General Assembly wanted to preclude, they knew this reg was coming. If they wanted to preclude it, they could have said.
But that kind of undermines your argument, because your argument is that at the time of this particular legislation was passed, the General Assembly knew that you were pushing for two or more, yet they independently chose one or more. So doesn't that undermine your entire argument?
No, because before then, it was clearly one. Now, that's what it said. But in neither case did it say that the grower processor had the right to make that decision in all cases. And it's not as if grower processors were prevented from entering into contracts with laboratories. It's not like they needed that grant of authority. So what did the legislature do when it changed the one to, unaccredited independent laboratory to one or more independent laboratories? Well, I think at the very least it sort of eliminated the argument that the department couldn't mandate the two-lab rule because of the use of the singular.
Well,
now,
I could come up with another hypothetical, which is basically telling grower processors that they aren't limited to contracting with one. They can contract with more, which actually would be a good thing for the grower processor, particularly if there's a supply issue. If there's one lab that does have predominant market share and they can't get their testing done timely, they have a list of approved labs that they can go to get their product tested so they can get it to market quicker. That would be the reason to give them authority to contract with one or more.
Before you answer that, if that was a question, I would argue that what it does is it gives the department the option of requiring independent testing by two different inspectors. But, okay, so now, is there an ambiguity?
No,
What happens if there's an ambiguity?
well, if there's ambiguity, then the court can look to the other factors set forth in the Statutory Construction Act. We're not arguing ambiguity. We're not getting into Chevron or that whole world. What we're saying is that when you read 704A, in the broader context of the entire Act, where the legislature said, among other things, that safety is paramount and that the way to protect patient safety is through careful regulation, does it make sense to read 704A to say, in this one very narrow area, we are going to preclude the department from regulating and give grower processors the right to resist regulation?
Well, again, you're resorting to arguments outside the text, and you've conceded it's not ambiguous. And if you are a grower processor and you read the law that's been enacted, are you not entitled to stand on and rely upon the enacted law, which says that you, grower processor, shall contract with one or more? It could be one, it could be 1,000, it could be 1,000,000 independent laboratories to test the medical marijuana. I guess, let me just ask one more time. How does this sentence give because the department's not mentioned in that sentence. The department's mentioned in the next sentence in a different context. How does that sentence give you, the department, the authority to say, no, General Assembly, we know better than you, so we're going to get rid of this one option and mandate more than one? How do you get the authority to do that?
We don't from that sentence, but it doesn't preclude it. That's the question. It says, shall contract with one or more. The department has simply made that choice and said, in the exercise of our judgment, it is better for the program as a whole if we require two laboratories.
Counsel, let me ask another question. Is it your position, given the broad grant of authority, whether that's given to everyone else or not isn't really the point. You have a broad grant of authority here. Is it your argument that any limitation on that authority needs to be explicit?
Yes, if we're talking about regulations that are otherwise within the scope of the authority and that further the purpose of the statute. And I think that was the relevant question in Marcellus Shale, to some extent in the Gilligan horse racing case that we cite. If there's a broad grant of authority, then once you reach that step, statutory language needs to preclude regulations.
I guess if that's true, I mean, if that's the law, then the clarity of this first sentence, assuming that it is, clearly is not an express limitation on the department's authority.
Absolutely. Now, the legislature, I'll be candid, could have limited the department's authority in sort of a roundabout way by saying, a grower processor shall have the right to choose whether to contract with one or more. But it didn't use that language. It said, shall contract with one or more. The department hasn't required grower processors to violate that. They have simply said, we're going to make that choice.
But a grower process, I mean, this is an interesting twist on concepts of regulation, right? Because what you're arguing is that when the General Assembly gives a general grant of authority, it also is an explicit and express grant to make choices where the General Assembly has remained silent. Do you have any kind of case law or anything to back that principle up? Because it does seem to be a little bit contrary to the idea that if the General Assembly is going to say X or Y, and you're in the department, and you're saying the department now has the option to choose X or Y, the law that I'm familiar with would be the General Assembly would have to explicitly say the department can choose X or Y, but you're saying no, the general grant of boilerplate authority is adequate. I'm concerned about how this principle would apply going forward in a broader sense.
Well, so as an initial matter, any grant of regulatory authority has to be within constitutional limits. It can't, it can't be so ambiguous that it would let the agencies act as sort of roving legislatures. But subject to that limitation, where the scope and purpose of the regulatory authority are set forth, where the scope is very broad and the purpose is clear, here it's patient safety and efficacy, it's not making life easier for grower processors. If the General Assembly wants to limit that authority and prevent otherwise valid regulations, then it should speak in clear terms. Because implicit in that question, I think, is that if 704A didn't exist, the department probably would have this authority. This regulation would be fine. We wouldn't be here talking about it. So,
well, if the statute had said grower processors shall contract with a minimum number of laboratories as determined by the department, we wouldn't be here.
Absolutely, yes.
But the statute, and that is an express, clear, unmistakable delegation of authority to the agency. But the statute doesn't say that. And I guess I'm saying, what is the equivalent of this language that I just said that is in the statute that provides a clear, express delegation of authority to the department to choose whether to allow grower processors to use one lab or require them to have a minimum of two? Where's the equivalent of that language that isn't there?
So if we look at 704A in isolation, we can't get the authority from there. We haven't tried. And, I think this is where Commonwealth Court essentially began, and ended its analysis, is it just looked at 704A and said, does this give you the authority? And we're conceding it does not. But there is a broad grant of authority. And I think the Marcellus Shale, the two lead opinions in that case, really do go through a very similar analysis, recognizing there's a broad grant of authority. And in that case, actually, there was a more specific delegation to the department and the Environmental Quality Board to take certain steps. And the question was, had they exceeded the limits of that more specific delegation by bringing in things that were arguably outside the scope of what they were. And the court, Justice Donahue, in the plurality opinion, Justice Weck, relied on the fact that the legislature had spoken capaciously, and the court respected that decision by the legislature to say, we are going to give the department, or the board in that case, the authority to regulate as it believes necessary to effectuate the purposes of this act. And I agree, the legislature could have been clear no matter what, no matter which way you're arguing. In passing Act 44, they could have used clearer language if they wanted to either prohibit the two-lab rule or if they wanted to mandate it.
Marcellus Shale's a little different because in this case, we're focused on the language that says the grower or processor shall contract with one or more. No reference to the department. In the provisions that do spell out in 301, the department's authority or the department's mandate, you're instructed as the department to develop a 4-hour training course, develop a 2-hour course. Would it be your view, similarly, since your authority is so broad, that you could have said, well, thanks, General Assembly, for telling us we have to develop a 4-hour course for these people and a 2-hour course for those, but we're going to make it a 5-hour course and a 3-hour course, or a 3-hour course and a 1-hour course, since you think you can vary the one or more to more than one?
So I think that presents a different question, and that is more analogous to the Marcellus Shale analysis, because there the question was where you've got a subsequent, more specific delegation to the department. How does the language of the more specific delegation perhaps limit the authority of the general delegation? Here, 704A, the first sentence, doesn't mention the department. So to read it as a limitation on the department's authority, you really need to sort of see it as kind of an indirect way of giving the grower processors a right. That's the only way you get there. You have to read shall as shall and in their own discretion may choose to, or, essentially something that isn't in there.
Well, that seems to me to be contrary to the whole purpose of the statute that allows the department to develop regulations. There's nothing in any of the statutory terms that allows the growers to develop regulations.
Absolutely. Yeah, and that is, we haven't argued 704A is ambiguous, but we do think that the interpretation of it needs to be informed by looking at the statute as a whole, looking at the structure, and looking at what the legislature was trying to accomplish.
That sounds like you think it's ambiguous.
Well, if it were just 704A by itself, we might say it's ambiguous, but it's not. It's 704A as part of the Medical Marijuana Act, and that requires.
It also sounds like a federal statutory construction application as opposed to how we interpret statutes under Pennsylvania, because we look at the plain language to determine the intent first, and then only if it's ambiguous do we look at the broader aspects of the statute. We don't take this holistic approach to avoid plain language of a statute.
Well, I would maybe disagree a little bit, which is that where, I'm just saying look at the plain language of the rest of the statute in conjunction with 704A. So look at the plain language of the stated purpose of the act. Look at the plain language of the direction to the department to regulate medical marijuana. Look at the repeated emphasis on patient safety and product efficacy. So look at the plain language of all of those provisions and then plug 704A into that. And as the Chief Justice was alluding to, it simply doesn't make sense to say that in the middle of this act, which is all about patient safety, all about efficacy, all about regulating this industry, which continues to be illegal under federal law, the department would say, okay, well, we're gonna hamstring the department in this one very narrow area and give grower processors the unrestricted right to make this decision.
Well, they're allowed to do things that don't make sense. They're elected. They do all sorts of things that everybody in this room may think, boy, that does not make sense. But that's why they stand for election every couple of years. And if they use the word one, I just struggle with how the department gets to delete or nullify the word one.
The department has, in our view, one is a floor. And the department has decided that it is going to require more than the mere minimum in the statute. It does not set a ceiling by the plain terms of the statute. And the department has said, we think that testing with 2 is the way we can exercise our authority under the Act. We can perform our statutory obligation to regulate this program to protect patient safety.
So that's a great...
Makes sense, given that it's a disjunctive sentence.
So that's a great answer to that question. And this goes to my last question about the creep of this case, which is if the General Assembly sets a minimum floor for something, let's say the General Assembly set a minimum floor for an environmental standard of some kind, and says, the discharge of your pollutant shall be, I can't even, I'm not smart enough to come up with one on the fly. Let's say they set a minimum standard. And then they have a general grant of regulatory authority to an agency to promulgate regulations to implement the statute as necessary for the agency. Under your principle, the agency could promulgate a regulation that resets the minimum as long as it's not lower than the floor.
So, yes, but subject to 2 important caveats. One, it would have to be reasonable. Reasonableness review is always an option for anyone challenging a regulation.
But not from a conflict perspective. There's no conflict there. If the General Assembly says minimum of X, as long as the agency has a general grant of authority, they can set the minimum of X plus something, and you're saying that's within their authority.
Yes, but it's also within the power, obviously, of the legislature to limit that authority. And the General Assembly certainly has plenty of experience dealing with agencies they think have gone too far and rating those agencies in through legislation. So I don't think the risk of creep here is as great where the General Assembly has the tools at its disposal to limit what an agency does. I mean, I keep coming back to this, but if the agency wanted to stop the 2-lab rule in its tracks, it could have done that. It didn't do that clearly. And that's why...
Well, see, again, I'm disagreeing with you on the way regulation works in Pennsylvania. It's if you wanted to have that authority, that same argument could be you needed to go to the General Assembly and get it. Not that the General Assembly has to stop you.
Well, the scenario is where the General Assembly has already made a choice, already given the agency the broad authority. And I think while I understand there are some boilerplate grants of authority, they're not all the same. I mean, I think if you look at some of the cases involving the Public Utility Commission that my friend cited, they involve narrow grants of authority where this court has found that there wasn't the broad, capricious grant of authority. But if you look at a case like Gilligan, which is a horse racing case, this court said, well, the General Assembly has chosen to give an agency a very broad grant of authority, and we are going to honor that choice. So if the goal of statutory interpretation, which it is to honor the intent of the legislature, that requires respecting a choice to give an agency broad authority as well as respecting a choice to clearly limit that authority.
Counsel, can I ask a follow-up question, sort of? Is this dual inspection protocol that the department has enacted, is that part of its enforcement powers to be certain that all of the the product that comes from the processors meets certain specifications? Is that an enforcement?
Yes, absolutely. Yeah. I mean, one key purpose of the testing is to ensure that there are no prohibited impurities, for instance.
I mean, you have a specific grant of authority under 3018
Mm-hmm.
to develop enforcement procedures. I mean, I'm just struggling with this notion as to why the legislature would have to be specific as to this one enforcement procedure.
Well, partly because I think this isn't just about enforcement. I mean, it is related to enforcement, but it goes beyond that. For instance, it involves the labeling of medical marijuana that's offered for sale. Well, based upon the tests, yes. But the department, the department, again, isn't, we're not a party to those tests. Those are, the grower processor is a private entity, the lab is a private entity. So the department doesn't always have total insight into what's going on there. It's using the tools at its disposal. And if we wait sort of until we get to the enforcement stage, oftentimes it's too late. And that's why, again, the department acted essentially before a problem that it saw was likely to develop actually did occur.
I'm not sure I understand your answer, because it seemed to me that Justice Donahue was throwing you an alternative lifeline, which you are reluctant to grab onto.
So
that's because he knows enforcement happens after a violation, not before a violation. That's.
I apologize for that. I think there are. I want to say this: the department could justify this authority in a number of different ways. I think it could tie it to enforcement. It also, it's interesting. Green Analytics here has argued, actually, they've gone further than Commonwealth Court. They've argued the department doesn't have authority to regulate testing except for a few specific areas. But one of those areas is accreditation. So could the department adopt this regulation as a condition of accreditation, say to a lab, you get to only test one company's medical marijuana at one stage, or we're not going to recognize you? Perhaps. The department does have different specific sources of regulatory authority.
Isn't that already the case, though? If you've set a regulation that says you have to have 2 labs, then you can use a defiance of that as a reason not to accredit, right?
Yes, sorry. I was just saying, as a belt and suspenders, there are other places in the statute where the department could derive the authority as well for this regulation, just as Justice Donahue was pointing to the enforcement provision as a possible way of bolstering the department's authority here.
This is an otherwise illegal activity.
Yes.
And this is one of the few, if only, areas where Pennsylvania is regulating an activity such as this medicinally purposed marijuana.
Yes, I'm not aware of any other area where Pennsylvania regulates something that's illegal under federal law, where Pennsylvania regulates and allows it to be used.
All right, any other questions for Mr. Fisher? Thank you very much.
Thank you, Your
hear
Honors.
from Attorney Cassell. And have I pronounced your name correctly?
Judith Castle.
Castle, thank you.
Also with me is Micah Busey, my partner, co-counsel. If it please the court. I think I can answer some of the questions and also respond to what my opposing counsel has said here. This case is about the Department of Health seeking to replace the General Assembly's policy decisions in the Medical Marijuana Act with its own. This it cannot do. Under the Marijuana Act, DOH has regulatory authority over specific activities, but Section 301 and 704 limit the department's authority when it comes to testing and laboratories. Specifically, under 704, as this court has noted, it provides that grower processors contract with 1 or more labs. DOH's 2-lab requirement mandates 2 and only 2 labs. They issued this 2-lab requirement despite members of the General Assembly, the House Health Committee, members of the industry, and even IRC expressing serious doubts as to whether the department had the authority to mandate this 2-lab requirement. We went to the Commonwealth Court and we asked them to rein in the department's overreach, and it did. And we respectfully asked this court to affirm that Commonwealth Court's decision. Now, you've noticed that the department has basically argued 2 things. First, that it has broad blanket authority over testing and laboratories. And second of all, that should a lab be able to test, a single lab, test both the plant and the final product, somehow that makes the program completely unsafe. Neither are true. Taking to the department's first argument that they have broad regulatory authority over testing in laboratories, 301, and they cite to 301. 301 says that the department will have regulatory authority over growing, processing, sale, and use. Notably missing in that list is testing. It is unlike Marcellus Shale, it is unlike Gilligan. When the General Assembly provided a list, it also said that the agency could include but not be limited by that list, and or they shouldn't be prohibited from the broader powers previously expressed. In this case, none of those words exist. There is a straight list of activities under which the General Assembly thought the department had regulatory authority, plain and clear. Now, DOH may argue that testing should be subsumed in growing. The problem with that is if 301 was silent on testing, that might be believable. However, as you all know, later down in section 301A44, it specifically gives the department the task, the obligation of monitoring. The department trivializes monitoring. Monitoring is the way that all other states who have passed medical marijuana use for regulatory oversight over their labs. The department even cited to an article in their brief that they say stands for the proposition, the impetus of the two-lab requirement. Do you know what that article recommends? It recommends monitoring over the labs as the form of regulatory oversight. As for us, attached to the PFR, our PFR, we attached an affidavit from a former Maryland commissioner under the medical marijuana program who was specifically tasked with coming up with the regulations in Maryland. She also attests, yes, monitoring.
Counsel, are you suggesting that the department, if we were to accept your argument that one lab was allowed for both the testing at both points, harvesting and point of sale, are you suggesting that the department has the ability and the right to monitor the actual testing itself with their own independent experts?
I do. I do.
Wouldn't that effectuate the same exact concern of patient safety and product efficacy that the department kind of raised?
If I heard you correctly.
Wouldn't that protect? I mean, the department has raised its particular two-lab requirement as promoting patient safety and product efficacy. If the department has the ability to monitor actually the testing itself with one lab at the harvest as required and at the point of sale as required, wouldn't that alleviate the department's concerns?
Absolutely. We not only agree to that, we want to promote that. We think that is what should be done.
Who pays for that?
Well, under our proposal, it would be the labs.
Isn't that what this is all about?
Pardon me?
Your clients don't want to pay for a second inspector. Is that the problem? I mean, I'm groping for why the opposition to this.
Oh, great. Thank you for the question. No, it's because and I don't want to get into the third prong under tire jockey. I'm not trying to do that, but I am trying to answer your question. From the inception of the program, many grower processors picked a single lab, right? They picked a single lab because if you do more business with that lab, you get volume discounts. They can pass those volume discounts on to patients, right? So there's a financial incentive for both the labs who can have more business and the growers who can save money. But truly, how it's done in the business is if I'm a grower processor and I want to grow plants to make into pills and I want to grow plants to make into vapes, right? I use the one laboratory for all of it sometimes. But sometimes I use the one laboratory to test the plants and the final product here, but then I'll use another laboratory to test the plants and the final product here, and I'll do another lab to test the plants and the final product here, because this lab might have expertise in testing pills, this lab might be expertise in testing vapes, and this one might have expertise in testing suppositories, right? The reason I want one lab is so that if I have the same people, same processes, same equipment, testing this plant, then it goes through the process and they test the final product. Just like all of our biology classes in high school, you try to keep all the factors that you can constant. That's what the grower processor is trying to do. Because if something is amiss between these two, you had 15% THC here, and when you had the final product, it was only 10. You've used the same laboratory, so the difference, the mess up, is in your process, and you can look at it and go back and fix it. They really, really want one lab testing both ends of that scenario so they can know. Let's think about it. If you're using one lab that uses these people, these equipment, different processes to test a plant, and then you use another lab to test the final product, how would you compare those two results? What sense would they make? You're testing two different products with about 5 different variables. And they don't want that chaos in the market. They want some consistency between the products. They want to be able to make sure they make safe products. And what happens, which isn't explained in any of the regs, what if those two different testing labs that we're forced to use come up with different results?
Well, that's a good argument, and I don't remember much from 8th grade biology, but that did make sense to me about keeping the constants. But you're arguing in that sense that the regulation was unreasonable, not that the department didn't have the initial authority to enact that regulation. Are those two different things?
Absolutely, and I tried to preface that in the beginning, that that's really the reasonable prong of the jockey, but it does help kind of set the stage, like, why would anyone want to use more than one? Why wouldn't anyone mind using 2? Right. I just kind of wanted to give a little bit of the backdrop, and that's in our briefs.
No, I liked it. It made me think about junior high.
All right,
You were responding to a question, I think, but let me bring it back to the actual statutory language, because I think that's what we're here about. And in this first sentence of 704A, the General Assembly chose, it may have been silly, it may have been stupid, we're not here to argue about that. They chose to give you the opportunity and the responsibility to contract, the grower processor shall contract with one or more independent laboratories to test. Isn't your argument that you're entitled to stand on that language? And they said it can be one or more, so if you choose one, then it's one, and if you choose more, then it's more, and that the Department of Health doesn't get to come in and make a rule that says it must be more than one. Isn't that the whole argument?
Absolutely, 100%.
But the department can, under this, the department can control which labs you can pick in terms of certification of labs.
I'm not sure that it can, and it hasn't. It doesn't.
Doesn't the rest of that section talk about labs certified by the department, a laboratory certified by the Department of Health?
In the second sentence in 704?
Yeah.
Second sentence of 704 is really talking about how testing results are reported. The department is given the task of determining the manner in which a lab reports testing results. That's a little different. But back to your first sentence, you're right. The department's not in that first sentence. And the obligation is about contracting, not the number. It's always been the case, even in the regulations as well as the statute, that before any testing results can happen, and that's why sentence 1 and sentence 2 are temporally.
So when it says the department shall approve a laboratory under this subsection, what is the department approving or disapproving?
Well, a laboratory applicant will come to the department, and the department will review their standard operating procedures and ensure ISO certification, which is different.
Right. Well, that's what but you said no. I'm saying so you have to use a department-approved lab.
You have to. Oh, I'm sorry, I didn't catch that. I apologize.
You have to approve.
Yes.
I said certify. Maybe I was using the wrong
that's
term.
fine.
But the department, you can't just contract with any laboratory. You have to contract with a department-approved laboratory, and presumably the department is only approving laboratories that are going to be safe to the public. I assume they're not going to approve unsafe labs. So you don't disagree that you have to contract with an approved laboratory?
Correct. I'm sorry if I misheard you. Yes, and that's important because I started to say it's a different time. The first sentence happens at a different time than the second sentence. So DOH's conflation of both those don't really work. It really is about a grower processor entering into a contract. They have to do that before any testing is done, right?
But they can only contract with department-approved
Only
labs.
contract with approved ones. And the rigor that the department puts a lab through is extensive. These labs are not just anybody who wants to be a lab, as you have pointed out. These are labs that have gone through. ISO certification, by the way, is where a third-party accreditation service actually comes in and just goes through the lab with a fine-tooth comb.
Could the department, as part of its approval regime, approve labs for testing pre-processing and approve labs for testing post-processing?
That would be far outside the statute. There is no provision that, the first sentence doesn't have the department in it. It talks about the grower processor's obligation to enter into a contract.
No, I understand, but I'm just saying, I mean, this is going to one of the arguments that was raised, which I thought was an interesting argument. Could the department say, we believe, we have the authority to decide which labs are approved for testing, and we believe that there are certain this is the regime to get approved for pre-processing testing, and this is the regime to be approved for post. You can apply for both, but we may not approve you for post. We may only approve you for pre.
I would argue that they don't have the authority to do that because the Act is really specific when it's talking about who gets permitted for what, and it's really specific.
It might be better if you just said, that's not in front of us right now.
That's not in front of us.
Yeah, because if the department loses this case, Plan B might be Justice Brobson's approach, because that would be a much stronger case for them. Wouldn't you agree?
I hope he's not allowed to come back up.
Wouldn't you agree that they'd be on firmer ground?
I suppose I haven't looked at that, and this court isn't looking at that. I would argue that because of the 50 examples in the statute that require and dole out to the department exactly what permits they can and cannot issue, it might be a problem for them, even if they came back with that. I mean, I'm sorry?
Why aren't we looking at it? We're being asked to interpret a statute. Our review is de novo.
Correct.
We look at that sentence and say what Justice Robson said. That's our purview. I mean, we aren't stuck with the arguments that were developed as to interpreting the statutory language.
I agree with you, Justice Donahue. I really agree with you. And that's why I kind of started to answer the question, even though it's technically not before the court, because everything's before the court. The whole act and the whole regulations are.
Always. I mean, but this is a de novo review. We're being asked to interpret the language of a statute.
Yep.
Start with a blank slate.
Right.
Well,
right.
what we don't have, though, is we don't have a reg. This would be very interesting. If we had a reg from DOH which said, menu A is the list of approved, that we, the department, have approved, this list of labs for harvesting and testing, and this list, and then this separate list is those we've approved test for final processing. And guess what? The Venn diagram doesn't intersect. So they have gotten around in that scenario the one part of the one or more. You see, but we don't have that scenario. You follow?
Right. They haven't proposed that
regulation.
But
they could conceivably could do that. But that's not this case.
You want me to argue that? No, because I can argue that too if you like.
I'm taking you on a frolicking detour. I'm sorry.
I've enjoyed it. That's okay. More questions, or should I resume with my presentation?
Are there any other questions? I think you could conclude. We understand your argument.
Okay. If I'm not, I just want to say that just a quick recap, 301 really only provides the specific activities. 301 later provides for monitoring. Almost everything else is in Section 704. But I would argue that 704 lays out a very comprehensive testing scheme and laboratory scheme. That Section 704 is titled laboratories, and that's where the General Assembly found fit to put all of the testing in the laboratories. We all know about the one or more, and we talked about the permitting process. The manner in which testing results are required to be reported by DOH is also very extensive. I will skip that for now. But the one point I really, really would like to talk about is the line where it says grower processors shall contract with one or more labs to test the medical marijuana it produces. Medical marijuana is a statutorily defined word. It literally means both the plant and the final product. That sentence literally reads that a grower processor can contract with one lab to test both the plant and the final product. That literally forecloses DOH's interpretation of that act that says, well, we can just get rid of a lab because we can have two labs test both the plant and the final product. That's not what the General Assembly is saying here. The General Assembly is saying, grower process contract with one, and that lab can do both the plant and the final product. That is significant. Defined terms are important.
Okay, thank you.
Thank you. Thank you.
Well argued, Mr. Fisher and Ms. Cass. Want to call the next case, Mr. Minner?
Good morning, Your Honors.
Good morning. In this appeal by allowance,
I'm sorry, Your Honor, I have my partner, Casey Green, as my co-counsel.
all right, thank you, welcome. In this appeal by allowance, we consider whether prosecutors who, in the course of their prosecutorial functions, used and disclosed recordings which were obtained in violation of the Pennsylvania Wiretapping and Electronic Surveillance Act were protected from civil suit for damages by high public officials or prosecutorial immunity, despite the Act's express waiver of sovereign immunity. Please proceed.
Thank you, Your Honors. The question presented is whether law enforcement officers are immune from civil suits under Section 5725 of the Wiretap Act, and we respectfully submit that the answer to that question is no. I begin my argument with this Court's pronouncement in 1991 in the case of Commonwealth versus Hashem, in which the Wiretap Act was interpreted. And this Court stated, and I quote, "No violations of any provisions of the Act will be countenanced, nor will the failure of prosecutors to diligently follow the strict requirements of the Act be lightly overlooked." And then in Betger versus Miklich, decided by this Court in 1993, the Court stated, because the Wiretap Act, quote, "is in derogation of a constitutional right, the right of privacy, it must be strictly construed," end quote. Now, in 1978, the General Assembly enacted what is known as Act 152. And in Act 152, the General Assembly stated, "When the General Assembly shall specifically waive sovereign immunity, a claim against the Commonwealth and its officials and employees shall be brought only in such manner and in such court and in such cases as directed by the provisions of Title 42. 1 week later, in 1978, the Wiretap Act was enacted. And the Wiretap Act, apparently following Act 152, specifically stated in Section 5725B, to the extent that the Commonwealth and any of its officers, officials, or employees would be shielded from liability under this section by the doctrine of sovereign immunity, such immunity is hereby waived for the purposes of this section. So we know we have a waiver of sovereign immunity. No question about that. The next question is there a waiver or abrogation of the doctrine of common law immunity? For the DA.
There's just no waiver of governmental immunity, and so I struggled with this throughout my reading of this case. Why are we talking about sovereign immunity here in the
Well, Your Honor, thank you for the question, Your Honor. We took the position that because the defendants in this case represented the Commonwealth of Pennsylvania as 5 prosecutors. Okay. Well, that. Okay, well, I'll try to answer the question, Your Honor, and by addressing the specific language in the Wiretap Act. Section 5702 defines person as any employee or agent of the United States or any state or political subdivision thereof, and any individual, partnership, association, joint stock company, trust, or corporation. Our position is that the defendants in this case clearly fall within that definition of persons because they are employees of a state or political subdivision thereof, and they're also individuals. Well, 5725, and I'm just looking at it now, set. Again, Your Honor, our argument is that the language of the statute does allow a claim for civil damages under 5725 against the defendants who are named in this case because they are agents or employees of a political subdivision of the Commonwealth.
Would we have expected the legislature to add, after the words sovereign immunity there, local government immunity, high public official immunity, and prosecutorial immunity, so that it was clear that they were abrogating these common law immunities and the other statutes?
They certainly could have done that, Your Honor, but they didn't do it, and our position is it does not mean that there was no intent to abrogate the doctrine of sovereign immunity. And if I can...
No, I know, but I'm sorry to interrupt, but we understand they waived sovereign immunity. But my question is, if they were going to waive other immunities which had stood in some cases at common law for a long, long time, wouldn't we want, and in fact, wouldn't we require, given our precedent, that they make that waiver clear?
It certainly would have been better to make the waiver clear, but based on the provisions of the Wiretap Act, it's clear to us, our position is that the Act does require a waiver of the doctrine of common law immunity. And if I...
One more on that then.
Yeah, I could go through the provisions.
They said the doctrine, singular, of sovereign immunity. Do you maintain that there are no and were no other doctrines of immunity, plural, like a common law, high public official immunity, prosecutorial immunity, long recognized that common law, as well as the statutory local government immunity, I think that Justice Donnie was referring to. Do you maintain those are not other doctrines, or do you have some other reason why they were subsumed within this reference to the singular doctrine of sovereign immunity?
No, I think it's a separate doctrine, Your Honor, the doctrine of common law immunity, and it just was not expressly abrogated by the General Assembly. But my argument is that there are other provisions in the Wiretap Act that reveal that the General Assembly did intend to abrogate or waive the doctrine of common law immunity. And I was going to go through those sections, if I may.
As I mentioned earlier, we have law students here in the courtroom. And it may be confusing to them as well as to us at times, the differences between sovereign immunity, high government official immunity, prosecutorial immunity, and you refer to common law immunity. Right. Could you clarify the definitions for the students' benefit?
Yes, a sovereign immunity is a doctrine that, at least in Pennsylvania, has been created by statute. Common law immunity has not been created or established by a statute. It's a matter of common law that goes back a long time. That's the main difference, as I understand it. And in our case, our position is, if you look at the language of the statute, various provisions, it makes it clear, we think, that the General Assembly, in enacting the Wiretap Act, did intend to abrogate and waive the doctrine of common law immunity, irrespective of sovereign immunity. And that's what I'm going to get to.
Thank you.
Thank you, Your Honor. So I provided the definition of person in 5702 of the Wiretap Act. And then we have the definition of investigative or law enforcement officer, also in 5702, which says, in relevant part, any officer of any state or political subdivision thereof, or of the Commonwealth or political subdivision thereof, or any attorney authorized by law to prosecute or participate in the prosecution of such offense. So if you look at the Wiretap Act, law enforcement officers fall within the definition of both person and law enforcement officer. They can be and they are both. And there's a reason why the legislature separated them. And that is when the legislator specifically mentioned investigative or law enforcement officers in other sections of the Act, it was to prescribe unlawful conduct on their part, not to give them any immunity, but, for example, in 5717, 5713, 5713.1, and 57.26, the sections are limited to conduct of law enforcement officers, not persons in general, of which law enforcement officers are included within that category. Now, important to this appeal is also 5717. Investigative disclosure or use of contents of wire, electronic or oral communications, or derivative evidence. And in 5717A, the statute says, any investigative or law enforcement officer who, under subsection A1, B, B1, or C, has obtained knowledge of the contents of any wire, electronic, or oral communication, or evidence derived therefrom, may disclose such contents or evidence to another investigative or law enforcement officer to the extent that such disclosure is appropriate to the proper performance of the official duties of the officer making or receiving the disclosure. So here we have a section that only permits law enforcement officers to disclose intercepted communications to other law enforcement officers. Disclosure beyond that scope would be a violation of the Act. That's what this court said in the Caroli case. That's what this court found in the Betker case. And that's what the Superior Court determined in the Childs case. In all of those cases, the defendants, who are law enforcement officers, went beyond the scope of 5717A and disclosed contents of, lawfully in some cases, intercepted communications beyond the scope of to other law enforcement officers. And if I may submit, that's what the Commonwealth Court in this case got wrong. The Commonwealth Court conflated the use and disclosure provisions of Section 57.17, when it said, by carving out these acceptable use and disclosure provisions for law enforcement officers, the General Assembly specifically excluded law enforcement officers from liability under the Wiretap Act when their use or disclosure is done in the performance of their official duties, end quote. Incorrect, Your Honors, as to the subject of disclosures. Correct as to the subject of use, but as to disclosures, a law enforcement officer cannot disclose to anyone other than another law enforcement officer. That's clear in the statute, and it's clear in the case law by this court and also the Childs case.
So, counsel, in this particular case, how does that apply to what occurred in the Philadelphia DA's laws? They used an intercept, and they disclosed that information in a court proceeding.
Thank you for the question, Your Honor.
Let me back up a little bit, because
I will
may be in a different posture than my colleagues here, but the Wiretap Act to me seems pretty straightforward. Wiretaps are only conducted under a court order by law enforcement officials, and if there's a carve-out here, then the law enforcement official who misuses the wiretap or misuses the information divulged of it, this specific act requires that person, or provides that person can be found liable for that particular conduct, right?
Yes, Your Honor.
So
this is what happened.
Hold on. Let me back
I'm
up.
sorry.
I'm familiar with the facts. So in this particular case, you have not a law enforcement officer, a private person who intercepts another person's conversation, right?
Yes.
Gives it to the DA.
Yes.
And the DA uses it in a court proceeding, right?
Yes.
All right, so why don't we go into how that is not minimized, or how it's actually not protected or is protected?
Okay, here's what happened. The defendants publicly filed documents, motions, and responses to motions, which included quotations from these embarrassing intercepted recordings. Public filings, not under seal, not confidential. They were on the record.
And they did so without going to the court beforehand and saying, we have intercepts, and here's how they were intercepted, and we're filing a motion in limine. We want to know if we can use them or not. Because if they would have done that, they would have been acting under a court order, which actually provides them with immunity, right?
Yeah, but they didn't do that. They just
want to make sure we're all clear on that.
Yes, they filed everything publicly, not under seal. And the reason I make a point of this, Your Honor, and emphasize is that this court in Caroli specifically commented on that conduct, specifically commented on a situation where a prosecutor publicly files intercepted communications, and the court in Caroli said, and this was in 2013, it is not, quote, apparent why the motion to disqualify and supporting brief could not have been filed under seal in the first instance, or how filing these items under seal might have impeded their effective law enforcement use, end quote. That's at page 312. The Caroli court went on to say, quote, the plainly confidential nature of the conversation itself would appear to have made it apparent that their unsealed filing could lead to a broad public disclosure that would be inconsistent with the limitations appearing in 5717A and with the Act's broad objectives relating to the protection of privacy, also at page 312. Furthermore, the Caroli court said, quote, in the present context, the most obvious manner of accomplishing the appropriate investigative and law enforcement use of the intercepted communication would have been to file the motion and brief under seal. The failure to do so, as all parties acknowledge, caused the intercepted conversation to become a matter of public record.
Counsel,
Yes, Your
Does
Honor.
it matter that in Caroli, they were seeking a removal from office?
Yes.
And not a civil action?
Yes.
And if so, share with us why we should not distinguish this from the facts.
Yes, that language would be applicable to a case brought under either 5725 or 5726. And let me try to distinguish the two provisions of the Act, if I may. 5726 is not an exclusive remedy. It is a remedy that can be sought, as it says in 5726A, against any investigative or law enforcement officer, public official, or public employee to have them removed from office. Okay? Now, the reason why the General Assembly had valid reasons for providing a separate definition of investigative and law enforcement officer in 5726 versus 5725 is that it could not have used the phrase any person to identify potential defendants under 5726 because individuals who are not public employees or public officials cannot be removed from office. So that would appear to be why, in the statute, the General Assembly limited it to an action seeking removal from office of a law enforcement officer. Beyond that, Your Honor, there's another reason why 5726 should not be regarded as an exclusive or, in all cases, an adequate remedy for an aggrieved plaintiff. And that is, what happens if a law enforcement officer intentionally violates the Wiretap Act by making a disclosure such as what happened in this case and what happened in Caroli, and then that law enforcement officer resigns from office before someone can bring an action under 5726, or is terminated, or is laid off? There's no remedy.
Well, I mean, counsel, I think the answer to that, if the Commonwealth Court's opinion stands, is that's an issue for the General Assembly to deal with. But you spent a lot of time establishing whether there was a violation here or not. I haven't really gone into questioning in my mind whether there's a violation. The issue is when you have someone who enjoys not sovereign immunity, but enjoys high public official immunity or local governmental immunity or prosecutorial immunity, the question is, did the General Assembly waive that immunity for purposes of the civil damage consequence? Yes. It's not a question of whether they're subject to the law. They're certainly subject to the law, and they can commit a violation of law. We're talking about whether they can be sued into court in this action. So if we could go back to the point of, did the General Assembly explicitly waive sovereign prosecutorial immunity, local government official immunity, high public official immunity? Did it expressly do that? Because I think our precedent requires an express waiver.
Well, the Wiretap Act does not say we hereby waive the doctrine of common law or high prosecutorial immunity. Our argument is that when you look at the provisions of the Wiretap Act, the entire Act, there are many provisions that show that there was an intent on the part of the General Assembly.
And I appreciate that. I think you've laid out a fairly a good argument as to piecing that all together. I'm asking you, under our law, is that kind of piecing together little parts without an express clear waiver enough?
Yes, Your Honor, I think it is. That's what even in this case, the Commonwealth Court looked at the entire Act to see whether there was if not an express waiver, an implicit waiver. And in one of the cases that I cited, and I just can't recall which one it is now, but I'm sure it was cited in the brief, the same thing happened. So when you look at the definition of person under 5702, and then when you look at the provisions of 5725A, cause of action, any person whose wire, electronic or oral communication is intercepted, disclosed, or used in violation of this chapter shall have a civil cause of action against any person who intercepts, discloses, or uses, or procures any other person to intercept, disclose, or use such communication, and shall be entitled to recover from any such person. And then it lists actual damages, punitive damages, and reasonable attorney's fees. And one more point, Your Honor, if we look at 5713, which deals with emergency situations, and 5713.1, which deals with emergency hostage and barricade situations, in both of those sections, the General Assembly has included language that allows a claim to be brought against a law enforcement officer under 5725.
Counsel, procedurally, we're here because a demur was granted, correct?
I'm sorry.
We're here because a demur was sustained.
Yes.
And your request is not for us to decide on the merits. It's to decide whether this case should go back to the Common Pleas Court for determination. Why don't you argue that position? Because it seems you're going off into the far field regarding a merit analysis, and that's not before this court.
Okay. Then I'll go back to my original point, Your Honor. The case should go back to the trial court because looking at the provisions of the Wiretap Act, it is clear that the General Assembly intended that there would be no common law or high prosecutorial immunity for law enforcement officers. That's the specific answer to the question raised by this court when it granted the petition for allowance of appeal. That's the answer.
Counsel, what do we do with the fact that they didn't waive governmental immunity? I mean, when you're talking about common law immunities, there are immunities where it's within the purview of our court to define their breadth and application and things of that nature. But the General Assembly established two different immunities: sovereign immunity, governmental immunity.
Yes.
They specifically said here that the sovereign immunity, the Commonwealth's immunity provisions would be waived under these circumstances. But they didn't say that about the other statutorily created immunity, governmental immunity, that would apply to the district attorney's office. How do we grapple with that? I don't have nearly the problem with the court developed common law concepts of high governmental immunity and things of that nature. I do have a problem ignoring the fact that the legislature apparently made a concerted decision here that it was going to waive sovereign immunity but not governmental immunity.
Right.
How do we get over that?
Well, as Your Honor pointed out, they are two separate and distinct concepts. And even if the court were to find that sovereign immunity, does, as you said in your initial question, does not apply to the defendants in this case, the doctrine of common law immunity clearly does. And that goes back to my initial point. If we look at the specific provisions in terms of the Wiretap Act, we find enough language to show that it was the intent of the legislature, the General Assembly, to abrogate the doctrine of common law immunity.
So you think there's an ambiguity? I mean, it specifically waives sovereign immunity, but when you take a look at the Act in toto, there's multiple references to district attorneys, law enforcement officers, assistant district attorneys, attorneys authorized to prosecute cases. Our case law is rife with situations where we've identified those individuals as high public officials. So your argument is that there's an ambiguity in the statute?
Well, Your Honor, that's why I said in response to the first question that I think that sovereign immunity, our position is that the doctrine of sovereign immunity does apply to
high public officials.
Well, high public officials, but that certainly could include prosecutors, and in fact that...
Shorthand, you're saying it's a legislature shorthanded it.
Yes.
By saying sovereign immunity. Why is that a better reading than saying what they were doing was saying you can sue the DAO, but you can't sue the people who work there?
I'm sorry, Your Honor.
Sovereign being in this context, the district attorney's office. I guess you could sue them under one reading, whereas you can't sue the people covered by prosecutorial immunity. Wouldn't that be an alternative reading?
Yes, but I'm looking at the definition of sovereign immunity under 5725B, and it says the Commonwealth and any of its officers, officials, or employees would be shielded from liability under this section by the doctrine of sovereign immunity, which is hereby waived. That's why our position is that we actually think that prosecutors working for a municipality are covered.
There's the rub, because they're Philadelphia County. They prosecute in the name of the Commonwealth.
Right, that's it, Your Honor.
But do we give their nominal? Do we give preference to their nominal prosecuting posture, or do we give preference to the fact that they're employed by the County of Philadelphia, not by, they're not deputy attorney generals, for example?
I think that they are officers and officials of the Commonwealth.
Are they?
When they prosecuted Mr. Winig, they did it on behalf of the Commonwealth of Pennsylvania.
But they prosecuted another county?
In it,
They're Philadelphia County prosecutors.
right.
They represent the Commonwealth, but that doesn't mean they are the Commonwealth. I'm sorry, that wasn't a question.
Well,
That's what I'm struggling with here.
Here's the question. Under the Political Subdivision Tort Claims Act, Section 8541, except as otherwise provided by this subchapter, meaning the Political Subdivision Tort Claims Act, no local agency shall be liable for any damages on account of any injury to a person or property caused by any act of the local agency or an employee thereof or any other person. That's the immunity you have a problem with. That's the grant of immunity, and expressly says no cause of action except as set forth in the Political Subdivision Tort Claims Act.
So that would be the waiver of sovereign immunity.
No, this is local government immunity by statute. This is the General Assembly saying by statute local agencies and their employees are immune except as set forth in this act, meaning the Political Subdivision Tort Claims Act. And you don't have anything you don't have anything express. Your argument is it's implied that although there's no express waiver of government immunity under the Political Subdivision Tort Claims Act, they didn't amend that statute, they don't have an express waiver like sovereign immunity, you're saying it's implicit.
Right, that we have to look at the specific explicit terms of the entire statute.
Couldn't the General Assembly have intended, by not being explicit, intended that there are some circumstances under which you could hold a local government official liable because they can't establish that they enjoy local governmental immunity? Say perhaps they acted outside the course and scope of their official duties. Let's say we change the facts in this case. The prosecutor didn't just put things in a document filed with the court, but went to the media and leaked these things. One could argue they're not entitled to any immunity for that, and you could get civil damages under the Wiretap Act against them.
Right, and I agree, and that's what happened, Your Honor, in the Caroli case that I discussed earlier.
That was a 50, Carolee, and I knew
Carolee.
I knew Carolee, and you're not Carolee, Senator. No.
Okay.
Carolee was a 5726 case.
Yes.
And wouldn't if you look at the definitions, which you cited under 5702, investigative or law enforcement officers there include of the political subdivision. So that would include assistant DAs in Philadelphia County. But that gets you to 5726, because in 5726 you see the language about investigative or law enforcement officers, tying you back to the definition, right?
Right.
But that still doesn't get you 5725 for damages, right?
Well,
That's your problem, isn't it?
well, Your Honor, except that 5725 allows for a cause of action for damages against any person. And person we know is defined in 5702 to include.
Any political subdivision, you're right.
Right.
All right, Mr. Davich, oh,
Can I just ask you one more question?
Yes, Your Honor.
Assuming that we're correct, that in fact there was no waiver of governmental immunity, has that defense been waived by the district attorney because they have not raised it in their pleadings in the lower court? I mean, this came up in an odd fashion because usually immunities are raised in new matter. This was raised in preliminary objections, but if you're going to raise one immunity in preliminary objections, don't you have to raise all of them?
Yes, Your Honor. Thank you.
all right, thank you very much. Let's hear from Mr. Margolski, and did I pronounce that correctly?
Yes, Your
All
Honor.
right.
Congratulations, you're on the Criminal Rules Committee, right?
Oh, yes, Your Honor. Thank you. I appreciate. Thank you for that.
Or apologies, maybe.
Well, I was just glad that the per curiam didn't have any noted dissents. So may it please the court. My name is Dan Margolski. I represent the Office of the District Attorney and the individual assistant district attorneys named as defendants in this case. Your Honors, so this is a very straightforward statutory interpretation case. The Wiretap Act waives sovereign immunity. It does not waive governmental immunity, and it does not waive high public officer immunity or any officer immunity. The case law of this court makes clear in McKellen in particular that assistant district attorneys and district attorneys are high public officers who are who enjoy that immunity. And this court's decision in Doe also emphasizes that waivers of immunity need to be done unambiguously and explicitly. And here we have an explicit waiver of sovereign immunity. We don't have an explicit waiver or any waiver of governmental immunity or the high public officer immunity and the individual immunities at issue. And so that just resolves this case.
Would there be anybody in your office, counsel, who would not be protected in this case by those doctrines, say a secretary?
So in the
Paralegal?
if I can ask for clarification on the question, do you mean on the facts as alleged in this case, or?
On any facts. Let's take Winig had these tapes or whatever they were, these wiretaps, and they're released by not an ADA, but by a secretary or paralegal in the office. You're not maintaining that they would be shielded from Wiretap Act liability exposure, right?
So I agree. I think that they probably would not. And there are also circumstances where I believe it's in the Mattson versus Margiotti case involving the Attorney General and the immunity of the high public immunity of the Attorney General there. The court recognized that there could be instances of conduct that are palpably outside of that official's, even if it's a high public official, palpably outside their role, that they would not enjoy absolute immunity for.
Like if Mr. Krasner were out there on Dilworth Plaza handing out the transcripts of this thing, that would not be, for example, right?
Well, so transcripts of a court hearing or transcripts of the
yeah. The videotape of this, or the audio tape rather of Winig's whatever.
Right. We could come up with extreme examples that would where the individual would be acting so far outside of their official role that the immunity would not apply.
Counsel, yeah. Is there any circumstance where any employee of the district's attorney's office wouldn't be amenable to governmental immunity?
So I think that there.
And why didn't you raise governmental immunity?
Right. So I think the short answer to that, Your Honor, is that that's what in Durham versus McKellen is what this, which involved a case of basically tort claims against assistant district attorneys for their conduct in the course of litigation. It's directly on point in terms of establishing that that this particular kind of immunity, officer immunity, shields absolutely the in litigation official acts of district attorneys and assistant district attorneys.
What if it doesn't make it to litigation? Are you suggesting to this court that an assistant district attorney somewhere could somehow wiretap one of our phones and then leak it to the media and they would be immune from suit because they're an assistant district attorney?
Not exactly, Your Honor. No, and that may be another example of conduct that would be so palpably and manifestly outside of the official duties of the law enforcement officer or the assistant district attorney at issue.
Where do we draw the line? What about a press conference?
So, yeah, where do you draw? So I think, and in that particular case, the Magliotti case that I was referencing involving the Attorney General, the Attorney General there actually did send information that was allegedly libelous to the press in addition to sending it to a local district attorney. And the court there found that sending it to the press in that particular instance was within the Attorney General's official duties because keeping the public informed of the conduct of the Attorney General was an important aspect of that office. But Your Honor, your specific hypothetical there about, a district attorney wiretapping a phone of a Supreme Court justice, that is the immunity that we're talking about here in terms of high public officer immunity and the district attorney's office immunity really is strongest and is most compelling when it's within the when it involves conduct that is intimately related to the judicial process.
Sure.
Right? So that's the Imbler case in the United States Supreme Court. Obviously, that's not binding on this court, but it's the same pedigree of cases, the same sort of historical derivation. You have these officer immunities that are...
I think you're hitting on my point, because my point is this. We all talk about acting within the course and scope of your employment as protected conduct, right?
Right.
So you're an assistant district attorney. Your job is to investigate crimes, bring charges, prosecute criminal acts.
Yep.
In my understanding of high public official immunity doctrine, that's just nothing more than a common law recognition that the government doesn't act by itself, it acts through its employees. So therefore, certain employees who are acting within the course and scope of their employment on behalf of the sovereign immunity, are in fact covered by immunity, high public official doctrine immunity, right?
I don't think I follow you exactly, Your Honor, because I don't think that, to the extent you're saying that collapses into sovereign immunity because they're acting on behalf of the sovereign.
I'm not saying it collapses into it. I'm saying it's derived from sovereign immunity. It's a common law recognition of sovereign immunity and the limitations on sovereign immunity, which is that the government doesn't act by itself. It acts through its employees. So therefore, we have to develop an immunity doctrine that covers the employees acting within the course and scope of their employment, right?
So I agree. So I agree with the last part of what you said. I do think that these are very distinct doctrines. They come with different historical pedigrees. They have different reasons for existing, sovereign immunity versus individual officer immunity. But Your Honor is absolutely correct that the key reason why officer immunities exist, as opposed to sovereign immunity, why individual officer immunities exist, and that includes judicial immunity, high public officer immunity, is so that public officers can fulfill their duties to the best of their ability without fear of individual personal civil liability or being sued or deposed and so forth.
Right. So follow me down this path, if you would.
Of course, Your Honor.
We have an act here, the Wiretap Act. Now, we all understand, because of our backgrounds, wiretaps are usually conducted by law enforcement officials, correct?
Exclusively, yes.
Not always, not in this case. But, but no, I'm not going there yet. So you have an act that's specifically directed to members of law enforcement, DAs, prosecutors, law enforcement officials, correct?
Not exactly, Your Honor.
So why not exactly?
So the way the Wiretap Act works, as Your Honor knows from your time on the Superior Court, I'm sure, there's a broad prohibition in the Wiretap Act in 5703 prohibiting interceptions, using and use and disclosure of interceptions. That is a blanket prohibition that is wide sweeping, right? It prohibits me as a law enforcement officer, officer from doing it, or an individual civilian from doing it. And then it has a list of exceptions, right? And the primary or a big exception is for court-ordered wiretaps. And I've supervised a couple of court-ordered wiretaps. I think that's what Your Honor is alluding to.
No, that wasn't what I was alluding to. What I was alluding to was that the Wiretap Act is basically generated and directed towards members of law enforcement community and says what you can and can't do. There's a waiver provision for sovereign immunity, but there's also multiple references to the individuals, law enforcement members, police officers, assistant district attorneys, lawyers, prosecutors. They're referenced in here as persons who were identified and subject to civil liability. So my point is that although the Wiretap Act has a specific reference to sovereign immunity, and as you pointed out, it doesn't say it also includes high public official immunity doctrine, the Act itself provides for liability for those high public officials acting in violation of the Act.
So I disagree. I disagree with that, Your Honor, and I think it's important to
Tell me
explain
why. That's what I'm trying to get at.
Absolutely.
Why do you disagree with what I just said?
So the Act is not, I don't believe the Act, Your Honor, is geared toward law enforcement officers specifically. The purpose and structure of the Act is to prohibit interceptions, prohibit the use and disclosure of interceptions with exceptions. Some of those exceptions relate to law enforcement, some of them don't, right? I mean, technically, if you just reading the Act, right, we are being intercepted right now, right, by the camera, by this microphone, right? This is a technical means of recording my conversation. It's an interception. Has nothing to do with law enforcement, but the Wiretap Act does regulate it. It regulates it by saying this is, it comes under the exception of all party consent.
But the Wiretap Act wouldn't regulate our conversation.
But it does regulate any interception of our conversation, right? Even if done. So this microphone is intercepting our conversation, right? It's going to be republished by on YouTube or wherever, right? That's the use and disclosure of an intercept under the Wiretap Act, and it's lawful.
This isn't an intercept under the Wiretap Act. An intercept under the Wiretap Act is specifically definitional.
No, it is. It's any intercept. So an intercept is includes any mechanical recording of an oral communication, like what we're doing right now. So under the Wiretap Act, recordings of our conversations are intercepts. They're just allowed if there's all party consent.
Pennsylvania's a two-consent state, so you can't have a nonprofit advocacy group walking down into a restaurant and trapping a United States Supreme Court justice at dinner and recording them. That would be a violation of Pennsylvania's wiretap law.
That's correct.
Yeah.
That's right. And then there are some exceptions that would allow it. For example, the crime victim exception that was.
But we're not talking about an exception in this case. We're talking about an unlawful intercept that was given to an assistant district attorney. The district attorney's office then used that unlawful intercept by putting it in a pleading.
So we have to accept the allegations as they come in the complaint. But the allegations in the complaint are that this was a conversation, that there's a conversation. It was recorded by another individual, right? And that recording was provided to the district attorney's office. And the district attorney's office lost in its attempts to offer that into evidence. But,
let me back up there. You can't gloss over that one. It lost because it didn't seek an opinion beforehand from the judge that it was allowable to be used. Nonetheless, you could have filed a motion to eliminate, right, and said, Judge, we've got an intercept that the victim in this particular case intercepted from her husband. We intend to use it in evidence. Can we seek a motion to eliminate? And by the way, if you would have sought a motion to eliminate and had a court order, you would be immunized under the Act, right?
So I don't.
Is that a yes or no?
We would be immunized under the Act. We're immunized as we are right now.
You didn't do that. You put it in a pleading, and then you divulged the contents in the pleading, and then after the fact.
So we would. So if this were to go to trial or go to a summary judgment, past discovery, we would have vigorous factual defenses to that claim.
I'm just. For purposes of this particular case, as Justice Doherty pointed out in Demur,
exactly.
We're here to accept all well-pled allegations, and they're the allegations that are pled.
And that's one of the fundamental problems with a denial of absolute immunity in this circumstance, right? Is that anyone can allege. So the Wiretap Act contains an exception for crime victim recordings, right? And that's going to be. Those recordings are all going to depend on very fact-intensive questions about the victim's state of mind at the time of the recording.
The question becomes then, this taping was over a 7-year course period, and the exception says the commission or about to commit or other use and evidence.
Right.
So that's an issue separate than above here, but I guess your office will have to determine how using an intercept from 7 years ago when the person obviously didn't believe a commission or the person was committing an act or about to commit an act is now used 7 years down the line against that individual.
So again,
that's a separate issue before.
Right. Those are going to be factual contestations that we're going to have a vigorous defense on if it ever comes to that. Right. The whole point of the absolute immunity doctrine is that it's never going to happen. It should never come to that. And that's because in any instance where an assistant district attorney is going to use or disclose recordings under that exception or other exceptions to the Wiretap Act, in order for the interception to be lawful, it's going to depend on very fact-intensive questions about the crime victim's state of mind, right? If it's an all-party consent exception that we're invoking, it's going to depend on fact-intensive questions about who consented. It's going to depend on fact-intensive questions. So there's an exception to interceptions for jail calls, right? In virtually any significant prosecution where an inmate is in prison or is in custody of the jail, the assistant district attorney is going to listen to hours of jail calls, right? It's going to try to make use of those jail calls if they're relevant. In order for those jail calls to be intercepted lawfully, under the Wiretap Act, the prison needs to comply with its own policies and procedures. It needs to give written notice. It needs to do all sorts of other things.
This falls back to Justice McCaffrey's argument that you have a court order so that you could do that, or the fact that they're in custody and everyone knows that there's consent.
Yeah, so in order for the assistant district attorney to even make use of the jail calls, even before disclosing them publicly, right? In order for them to use them for investigative leads, in order for the district attorney to use them for impeachment, right, or anything like that, it needs to be established that there may be claims made by the defense based on facts that are unknown to the Commonwealth, that that the crime victim has credibility issues that is only known to the other party, right? And it comes out in cross-examination when we offer it in evidence.
That goes to the weight, not the admissibility.
No, Your Honor, it actually does go to admissibility, right? So if there is a motion in limine, right, or if there is a suppression motion for the recordings, right, and even if we don't disclose the contents of the recordings publicly, right, even if we're just arguing about whether they're admissible, right, because according to the defendant they were obtained unlawfully. And according to us, we would say they're obtained lawfully because the crime victim believed a crime of violence was about to occur, right? We have a factual dispute. I might interview the witness. I might try to understand the factual situation as best I can. Cross-examination happens. I'm going to try to offer it into evidence.
Yeah, but you're not going to cross-examine somebody on a piece of inadmissible evidence. I mean,
No.
if there was a motion to suppress and a judge suppressed something, and
It's going to be hearing.
Are you going to bring out the information that was suppressed or the document that was suppressed on cross-examination?
I'm saying at a pretrial hearing, right? At a pretrial hearing about the admissibility of the recordings, right? I'm going to try to offer evidence that it's intercepted lawfully. The other side is going to offer evidence that it was unlawfully admitted.
Right.
If the court disagrees with me and finds finds that the crime victim was not credible, right? Therefore, the recording was unlawful. Then retroactively, all of my uses and disclosures of that recording
Are out the window.
are not just out the window, but according to and they're suppressed. Can't use them at trial. Fine, that happens all the time, right? Suppression motions happen all the time. I've won my share. I've lost my share. It happens, right? Under the rule as articulated by the plaintiff, however, any use of an unlawfully obtained recording gives rise to civil liability, right? And as an assistant district attorney, given a recording that I'm going to argue is lawful, right? If I lose that suppression motion, it's determined to be unlawful. Any use that I've made previously of it gives rise to civil liability, including the fact that maybe I've used it as part of the evidentiary, or as part of the, even if it's not disclosed publicly, the factual predicate for filing the complaint in the first place.
Yeah, but you can
right?
litigate the admissibility of this particular tape by talking about how it was obtained in violation or in conformity with the act, without using the content. I think that's the distinction plaintiff's making. You disclose the content of an illegal intercept in a court proceeding, and that was subsequently found out to be suppressed by a judge, kicked out by a judge. You could have litigated the admissibility without litigating or without divulging the content, which is what gives rise to liability under the Wiretap Act.
But not just the disclosure of the use and disclosure of the content would also give liability. So
You're conflating two issues. It's not the use and disclosure of the tape. It's the use and disclosure of the content of the tape.
right. And
So again, if it's, I mean, I don't want to put myself in your shoes, but if I'm the DA, I'm going to go to the court and I'm going to say, Judge, I've got a tape, and here's how the tape was, in fact, obtained. And I'm going to seek a court order that says from the judge says when or whether I can use these particular tapes or not. Because if the judge says you can use them, I then have a court order, right? That's a court order. Can we agree on that?
a court order is a court order, yes, Your Honor.
All right. So I now have a court order, and under the Wiretap Act, the court order immunizes the use.
So the good faith reliance on a court order would immunize the use. But again, then you can, if you don't have the absolute immunity at issue, then you can just then they can just plead in a complaint that the reliance on the order was not in good faith.
Can I clear this up for myself anyway? Setting aside the court order issue, the good faith prosecution of a case by a prosecutor gives rise to immunity, whether or not we're talking about a court order, correct? I'm sorry to understand your question. Whether or not we're talking about a court order, the good faith prosecution of a case, steps taken in the prosecution of a case by a DA, that is subject to governmental immunity.
So, yes, Your Honor, but and even greater than that.
What's it?
Even beyond that, yes, Your Honor. So
sure. I was just trying to get beyond limiting it to a court order.
So, because but absolutely, Your Honor, yes.
Yeah, you're not limiting yourself to good faith scenarios because that gets into a fact issue.
And you're going to have to try your good faith.
They don't concede good faith here.
Right.
If we can get back to the statute,
scope, I guess,
I mean, if we can get back to the statute, because that's where I live.
Me too.
The definition, I mean, first of all, governmental immunity, high public official immunity, and a prosecutorial immunity, the three, although you didn't raise all of them in your demurs, and we're up here on the demur, so you didn't raise all of them, but let's just assume you did. They're always subject to a qualification that you acted within the course and scope of your official duties. So there could always be, you're not saying that those are absolute concepts of immunity where you as a person couldn't be held responsible for a wire. I mean, you conceded a factual scenario where you might intercept a friend's conversation and then leak it to a newspaper. You'd be violating the Wiretap Act. You couldn't get prosecutorial immunity, right?
Manifestly impalpable.
But the facts alleged here are all of the disclosures were made in a court proceeding. As an attorney for the Commonwealth, an employee of a local official, there's no allegation that there was some extraneous leak whatsoever, right? Outside that context. Okay, so we assume the facts as presented in the complaint. My question is, what are you asking us to do? Because we know that there was an express waiver of sovereign immunity. That's fine. You concede that there are circumstances that the immunity that you're arguing is not absolute. That just because you happen to be an assistant district attorney doesn't mean you are forever shielded from liability under this act. You concede you are a person, right? So what do you want us to do? Because it seems that all the immunity all the immunities that you are arguing about can coexist with the statute. That a person could argue immunity, but a court say you weren't operating within the course and scope of your employment. What are we trying to do here with the Commonwealth Court's decision?
So I think we should affirm the decision. Your Honor should affirm the decision.
Because there's no facts, there's no way under the facts alleged that you could ever be outside the course and scope.
Well, so I think course and scope is different from good faith and lack of malice, right? And that's where I think the Mariotti case, the 1950s case that recognized the high public immunity of the Attorney General in that circumstance, recognized that so in that case, the Attorney General accused an ADA in some county of being a communist sympathizer, essentially, and wrote to the DA of that county to ask that person to be fired and forwarded it to the press, allegedly, right? That conduct, even if it was malicious and done in bad faith and based on nothing but innuendo or even less, right? Even if it was done wrongfully and would have given rise to a libel claim, because the subject matter that it relates to is a communication between the chief law enforcement officer of the Commonwealth and a DA.
You're saying, just to cut the, you're saying that because because there's no allegation of malice, there's no allegation you acted beyond the scope, there's no allegation of, I mean, what additional things would they have to have alleged that would not have triggered the immunities you're talking about?
So, what would they have to allege? They would have to allege that it was not done, that the intercepts were not used by the Commonwealth, or sorry, by the ADAs in the context of a judicial proceeding or in anticipation of a judicial proceeding when they're filing a complaint. Or
what if the ADA just knew that it wasn't, to touch on Justice McCarran, what if the ADA just was like, we're never going to get this in, but I want to win this case in the case court of public opinion. I'm going to file it as an attachment to this motion that has absolutely nothing to do with it, and I'm going to file it and I'm going to be done.
So that would be outrageous, and it would be a cause for professional discipline.
Would it be cause for personal liability? Have they acted outside the scope of their immunity?
I think that it would. I think it would not, and I think that and the reason is because the allegation of malice and peering into the high public officer's mind at the time the conduct takes place.
But what if they alleged it?
So no, if they allege it, it still doesn't. It's still not enough, because then what you're doing is you're undermining the purpose of the high public officer immunity in the first place. The purpose of it is so that high public officers can engage in their duties and to the best of their ability and exercise their discretion without fear that their motives and mental impressions and so forth are going to be put at issue in a jury trial based on allegations in a complaint. And you can always allege malice, right?
So their only remedy statutorily then is removal from office. Because removal from office is not subject to any immunity.
So
you should probably say yes.
Is that the only? No, yes. Oh, sorry.
Maybe it's not the only, but maybe it's the statutory one.
No, I think that is the statutory one.
Okay.
And there may be, and I'm saying there's attorney disciplinary proceedings, for example, that there may be other remedies. But yes, no, I didn't mean to dispute that.
Counsel, let me ask you one more time. It seems to me that the much more straightforward, easier immunity to raise here, which would apply to any employee in Philadelphia County, including any employee of the district attorney's office, is governmental immunity. You're shying away from what appears. Is this a matter of principle that you would prefer to have this decided based upon a common law immunity as opposed to an immunity granted by the legislature and explicitly not waived here? I mean, explicitly not waived. They waive it as to the Commonwealth, but not as to local governments. Is there a reason we shouldn't be focusing on that?
No, Your Honor, and
other than the fact that you didn't raise it.
Well, candidly, I don't know.
Which I don't understand why. I mean, I'm really struggling with the state of the pleadings in this case, because just to me, as a former practitioner, you would go for the most straightforward defense that you have in the case, which is governmental immunity. I mean, it would be very difficult to plead around governmental immunity.
So candidly, Your Honor, I don't recall if that was raised as one of the bases in the initial demurrer. It may have been, I just don't recall.
Not according to what I've seen, but I mean,
Fair enough.
If I could follow, isn't that on the agency though? And I mean, that's not like a Bivens. That's not an individual. Like analogy to the Bivens in federal court.
Right.
That's to the agency in the local government setting, right?
Well, and the local, I read the the statute says the agency and its local.
The liability accrues, though, absolutely for the acts of the agents, but the liability runs against the entity, not its employees. Am I right about that?
Geez, you're,
Or 8542? A local agency shall be liable for damages. So this action couldn't be against the DA and the individual actors within the DA's office under 8542. Is that right?
I think I think so, Your Honor. But and I understand that that's not how the case has been litigated so far.
employees are subject to the immunity.
I believe so, and that's what McKellen also holds, and this is also partly because of the McKellen case in 2001, where the argument made there was that the Political Subdivision Act didn't abrogate the prior absolute immunity doctrine. But I don't,
whether it does or not. I mean, in the context of this case, I mean, the fact of the matter is you're not a Commonwealth employee. That's the only situation in which immunity was waived. Forget about one abrogating the other. I mean, it would seem that would be a straightforward way to address this case.
I think it would be, Your Honor. I think if there's issues with respect to, if there are issues with respect to waiver, however, Your Honor, I think the basis for the Commonwealth Court's decision is.
Well, we didn't take it on that ground. I mean, we
Right.
took it on a very simple question, which is whether or not you're immune from suit.
What we thought was a simple question.
Right.
At the time.
Right.
Do you want to wrap up?
If there are any further questions, I'm happy to answer them. But yeah, I think that you've got an argument, Your Honor.
All right. Thank you both. Mr. Minner, the court is going to take a 1-hour lunch recess. Case.
Pottstown School District versus Pottstown Hospital, representing the hospital, Mr. Dan Breyer, representing the school district, Mr. Randall Schauer.
Good afternoon. In this appeal, Pottstown Hospital filed an application for charitable real estate tax exemption relating to 3 of its properties. The trial court granted the exemption, finding that the hospital satisfied all of the requisites to demonstrate that it is a purely public charity. Pottstown School District appealed. The Commonwealth Court reversed, finding that the hospital failed to demonstrate that it operated free from a private profit motive due to the excessiveness of its executive salaries, as well as the fact that 40% of the executive's bonus compensation was based upon the hospital's financial performance. In so doing, the court examined the activities of both the hospital and its related entity, Tower Health. We granted review to examine whether the hospital demonstrated that it was a purely public charity entitled to real estate tax exemption, and whether the operation of entities related to the hospital should be considered when examining the hospital's tax-exempt status. Please proceed.
Thank you, Madam Chief Justice, and may it please the Court. My name is Dan Breyer, and I represent Pottstown Hospital. I'm joined today by my co-counsel, Carl Myers from Stevens and Lee, and my partner, Donna Walsh from Myers, Breyer, and Kelly.
Welcome.
There are 2 well-settled and very structural principles that animate this appeal. The first is that purely public charities are permitted to have compensation plans that pay their employees reasonably and at fair value. And of course
According to the market rate, right?
Correct. And of course that makes sense because purely public charities don't exist in a vacuum. They exist in the real world where they compete with other companies, both for-profit and not-for-profit. The second fundamental principle that animates this appeal is that purely public charities should not be punished for attempting to operate with a positive bottom line.
I think these are really good points, Mr. Breyer. Can I ask you, though, to come back to the constitutional words? What do you think purely public charity means in the constitutional text? And because by implication, there are then impurely public charities and purely private charities, and what do you think the framers meant by purely public charity, and should that bear on our decision?
I think it does bear on the decision, and I think what we do is we look to the Constitution of 1874. And when the phrase purely public charity was added to the Constitution in 1874, it was to prevent the abusive legislation that was being passed to favor certain constituents. So the court wanted some uniform higher standard for when tax exemption is available. In fact, there's a great quote from a case from the late 1800s that goes right to Your Honor's question. The quote is that the Constitution prefixes the term prefixes the term purely to intensify the word public, not the word charity. And that's because the notion of a charity evolves over time, as we've seen in many cases that this court has addressed. So purely public means it's open to the public, it offers its services either gratuitously or at reduced value to the public without discerning who's eligible for the services. It provides a public charity. It relieves the government of some of its burden. This, of course, is the Hosp test. And that it operates entirely free of private profit motive. This case is here today on that last prong. The Commonwealth Court found that Pottstown Hospital did not establish that it operated entirely free of private profit motive. But we're not in uncharted waters, because this court looked at that exact prong in the Wilson Area School District versus Easton Hospital case in 2000. And when it looked at that case, it was questioning whether Easton Hospital, which did business with a for-profit affiliate, Easton Hospital's affiliate was for-profit, and the hospital was loaning money to the for-profit entity with the expectation that it would increase the efficiency of the hospital. And this court, in looking at that, set a three-part test for what it means to operate entirely free of private profit motive. But it all boils down to this. Are the revenues of the applicant entity, here Pottstown, being used to advance the efficiency of the hospital and the eleemosynary principles of the hospital? And guided by that, we look at the relationship between Pottstown and its corporate parent, Tower. And the trial court made really critical findings supported by substantial evidence that travel with the case to this court. And those findings are as follows. When Tower acquired Pottstown from a large public for-profit healthcare company, Pottstown didn't have any of the human resources or the infrastructure to provide all of the core essential support services that hospitals need to operate. For example, it didn't have its own risk management department. It didn't have its own legal department. It didn't have marketing. It didn't have treasury. It didn't have accounting. It didn't have billing. What it did is it had 213 beds that delivered care, but all of the support services that a hospital needs to function were not provided or not part of Pottstown when it was acquired by Tower. So what did Tower do? It established a centralized administrative operation to provide those services, not just to Pottstown, but to the other 4 hospitals that Tower purchased from the large public for-profit company.
Pardon me, does Tower do that for a profit?
I'm sorry?
Does Tower make a profit on the provision of those services?
No, Your Honor. In the record, and this is at pages 297A to 299A, the fees that are charged by Tower, which is a 501c3, it's not a for-profit entity, but the fees that are charged by Tower to Pottstown are not marked up, they're at cost, and they're not available from a third party at a lower rate. So the answer is no, it does not do that for a profit. Now, what it does do is it allocates the cost of those services across the family of hospitals that it owns. In this case, 9.58% of those costs were allocated to Pottstown. But the record evidence is Pottstown couldn't have afforded those services or obtained them for less elsewhere, and the parent did not mark them up. So the trial court made really essential findings.
Could you just go back to that for a moment? They couldn't provide those services at a lower cost, and what?
So the applicant entity, Pottstown, could not obtain the services at a lower cost from a third party.
Could not obtain them because their operating agreement prohibited them from doing that?
No, the evidence was that it was in the context of there being no markup and that the services were provided at cost. The trial court made critical findings. The first one is, during the 3 years at issue, Pottstown had a net deficit of $97 million. It made it had $12 million of surplus in the first year, but over the 3 years it had a net deficit of $97 million. During the same period, Pottstown provided $86 million of charitable care. And there's more. During the same period, Tower provided $47 million of capital investment to Pottstown, mostly to develop a new information technology system. So I can't say it better than the trial court said it. Here's what the trial court said. These figures hardly indicate that Tower was exploiting Pottstown Hospital. The net winner here in this relationship was Pottstown Hospital. It could not have survived but for Tower. Tower underwrote the $97 million of deficit. Now there's an intercompany loan, and that intercompany loan is recorded because the entity still has its own balance sheet, it has its own financial statement, it's regulated separately from Tower. It is a separate entity.
They don't control any of their cash flow, though, correct?
So the way it works, Justice Donahue, is for Treasury purposes, the cash of Pottstown is upstreamed to Tower. But it's recorded, and there's a record of all of it. And the reason it's upstream to Tower is because Tower has the expertise and the resources to maximize the benefit of that aggregated cash.
And Tower's also a nonprofit.
It is, Justice Todd. Now, but I want to be very clear. Tower is not the applicant here today. Tower is the corporate parent of Pottstown Hospital. And I'm sure my colleague is going to make much about the amount of control that Tower had over Pottstown Hospital. But in the Wilson case, the Wilson Area School District versus Easton Hospital case, this court lensed the analysis not on the related party. It didn't look at the for-profit, Wilson, and say, oh, you're a for-profit, so derivatively the applicant loses. What did it do? It looked at the applicant and it said, was the revenue of the applicant used to advance the efficiency of the applicant and the, I knew I'd step on that word, eleemosynary purposes of the organization.
I understand that, but if it is being used in that fashion, it's because Tower is using it in that fashion.
Justice Donahue.
Tower is controlling the cash flow of the entity.
So,
I mean, this isn't a question of piercing corporate veils or anything of that nature. This is just a function of the structural arrangement between these two entities.
I want to be very clear. Pottstown Hospital had its own board of directors. It did not have the same board of directors as Tower Health. Pottstown Hospital had its own management team that ran the hospital. Pottstown Hospital management team and board of directors are responsible to advance the interests of Pottstown Hospital. Now, it is owned in a subsidiary of Tower Health, but there's a difference between having the treasury function consolidated and having this notion, I think the term in my colleague's brief is incestuous. He says, oh, the relationship between Tower and Pottstown is incestuous.
There's nothing wrong with the relationship.
Exactly.
It's just a question for our purposes when we're looking at the HUP test, whether or not the nature of that relationship impacts the analysis. And I don't ask any of these questions in the context of it being a pejorative, but I mean, to me, it's important to understand this. Now, in terms of compensation, Tower Health does control the compensation. Their executive committee, their compensation executive committee.
That's correct.
Which is a Tower executive committee, controls compensation issues.
That's correct.
Including determining whether the circuit breaker comes into play. I mean, it's a mathematical calculation or an accounting calculation, but that is a Tower Health function.
Board of Tower Health sets the circuit breaker.
Right.
The executive compensation committee of Tower Health sets the compensation. Mm-hmm. And the trial court, after hearing from 3 experts, all offered by Pottstown, my colleague on the other side, his client didn't call any experts to rebut the Pottstown experts. Here's what the 3 experts testified to: that the compensation paid to the management team of Pottstown Hospital was reasonable and within fair value. The compensation paid to Tower executives was reasonable and within fair value. But there's a really interesting additional finding, and that is that the compensation of the executives was the result of vigorous negotiation, the trial court's word, and good faith.
Yeah, but counsel, didn't the trial court also describe that particular, I think they labeled it eye-popping?
Yes, so the trial court...
compensation, and they said it was actually, that was part of the reason why the Commonwealth Court hung its hat on reversing the trial court, is it not?
I'm sorry, I didn't hear the
It's
end.
part of the rationale but why the Commonwealth Court reversed the trial court.
That's
because
exactly
of the
right.
eye-popping compensation.
The trial court did reference that eye-popping, and here's the context of eye-popping. Eye-popping is in the context of leadership of a large, integrated, nonprofit healthcare system. If the compensation at Tower is eye-popping, it's eye-popping at its peer organizations across the Commonwealth. The reality is, executives who lead large, complicated, regulated entities earn a lot of money.
Somewhat gratuitous comment by the trial court, and within the context of his overall findings, it's actually running the other way.
Yeah, it's like a...
But it's kind of gratuitous too, because for us state salaried employees, anything's eye-popping.
$2 million in compensation is eye-popping
For us.
for
But
us.
In this market that they swim, in that sea that they swim in, that's the market.
And they didn't pull these numbers out of thin air. When the Executive Compensation Committee of Tower was establishing the salary, they brought in Sullivan Cotter, a large, legitimate national consulting firm that analyzes executive salaries at hospital systems. And they looked at what Mr. Matthews' responsibilities were going to be after the merger. And you're going to hear from my friend, oh, but his salary went up so dramatically after the merger. It did. But so did his responsibilities. He went from being the CEO of a single hospital system, Reading Health System, to the CEO of a system with 6 hospitals. He went from $800 million in revenue to $1.6 billion in revenue. So did his salary increase after the acquisition? It sure did. But the acid test, again, we're back to that language in Wilson. The acid test is whether the revenues are being used to advance the charitable purposes. That's why they bring in the experts from Sullivan Cotter. In the trial, I'm sorry.
Just before you leave the compensation issues, separate and apart from the level of the compensation that was set for the executives of the hospital, how does the bonuses that factored from the profits of the hospital factor in when we're looking at whether or not the hospital operated entirely free from a private profit motive?
Justice Mundy, that's the crux of the issue from the Commonwealth Court's analysis. And here's how it factors in. The way these salaries were structured is they had a base salary. And then they had the opportunity, the management had the opportunity to earn additional compensation if the entities operated with a positive bottom line, i.e. above a very narrow margin of 0.4% net operating revenue. So the executive's interest in earning more money was perfectly aligned with the applicant's interest of operating efficiently and with a positive bottom line. Where the Commonwealth Court went astray is that it took the acid test of whether the revenues are being used to advance the charitable purposes, and they engrafted onto it this new notion that if a substantial portion of the compensation is contingent on the financial performance of the entity, it's per se proof of private profit motive. Here's the problem with that. The organization that is evaluated as to whether it has private profit motive is the hospital, not the individual working as the executive. That's where the confusion comes in. And we look at the cases where the court has said, oh, there was private profit motive. In fact, the Hupp case. In Hupp, the Hospital Utilization Project priced all of its services to the companies that they provided services to with the expectation of making money. And they didn't give any of their services away, and they, in fact, accumulated cash reserves. That is very different from the situation we're talking about here, with Pottstown Hospital and Tower Health. So to go back to your question, Justice Mundy, and I think this goes to the confusion that is in the atmosphere. The framing of the question about operating entirely free of private profit motive is at the entity, not on the management. And by the way, these guys don't set their own salary. Mr. Matthews is an employee. He answers to board members who serve without compensation. Those board members brought in experts. Those experts advised the board. And it was, as in the trial court's words, a vigorous and good faith negotiation. So there is no disalignment between the executive having an interest in operating the company efficiently to earn more money and the entity operating entirely free of private profit motive.
Counsel, in pursuit of your purely public charity, does the organization engage in a bill collection process for those who have not paid their medical bills?
Pottstown Hospital never sued a patient who didn't pay Pottstown Hospital. They write off the bad debt. That gets rolled up into that $86 million number that I talked about in terms of charity care. So the answer is no, they do not sue. Now, they may have collection efforts, you know, to remind people. I don't want to overstate it, but they don't sue.
That's not an issue here, but correct. I mean, we are not considering that issue, or the rates that are charged when computing the amount of public charitable care. I mean, whether they're insurance rates or whether or not they're Medicare rates or whether or not they're their published rates that nobody else collects. We're not dealing with that here.
You are not, because you're only dealing with the fifth prong of the HUB test. But parenthetically, the hospital provided 46% of its patients discounted care, and the average amount of the discount was 26%. But again, that doesn't roll into the fifth factor of the HUB test. The only issue before the court, and this is respectfully what I think the Commonwealth Court got wrong. The Commonwealth Court applied almost a Rorschach test to the executive compensation, and they found it to be inconsistent with operating entirely free of private profit motive. But they conflated the entities operating entirely free of private profit motive and the executive's interest in earning more money. So these organizations have to operate with a positive bottom line if they're going to be self-sufficient. If an organization like Tower or any of the other major healthcare systems we're all familiar with that are nonprofit lose money year over year over year over year, the charity they provide is going to go away. They can't sustain themselves. That's why I went back to first principles. Purely public charities are entitled to operate with a positive bottom line, and purely public charities are entitled to pay their executives reasonably and at fair value. And
it's not just entitled to, they're required to. Otherwise, they're going to get unqualified people getting the job.
Exactly. And they're competing against other organizations who are interested in that experience. And I'm sure my colleague is going to say, oh, but Mr. Breyer overstated it. Mr. Matthews never ran a 6-hospital system before he was advanced to run Tower Health. Here's what he did do. He ran Reading Health System that had an $800 million revenue a year. Reading Health System is the entity that decided to acquire the 5 other hospitals. The board had confidence in him and wanted to retain him. So to retain him, they brought in Sullivan Cotter, who said this is what would be reasonable. This is what would be fair market value. It's also very critical that in 2 of the 3 years, there was no incentive compensation paid because the circuit breaker wasn't met. So the problem with the Commonwealth Court's decision, it's even more abstract. It didn't look at what they earned, it looked at what they might have earned if they hit all of the bogeys that they would have needed to hit to earn additional compensation. So that's relevant because Sullivan Cotter says and Bruce Rosenblatt, who testified in the trial court, said they were well within what was reasonable in light of the fact that they never hit those additional bogeys. So I respectfully submit that this court doesn't need to modify the Hosp test. It's perfectly flexible. The Supreme Court has always dealt with these cases informed by the modern realities of competition. And the testimony is, and we saw this in the amicus brief of Hosp, 90% of integrated healthcare systems have incentive compensation plans. 69% of those health systems have some financial component that's part of the incentive compensation plan. And unless there's questions, I'll wrap up with this.
Well, I have a question. So there were a couple of years in the years at issue in this case where the hospital was losing money. It was bleeding a lot of money, but the company remained afloat. I mean, the hospital remained afloat because of Tower Health's infusion of money into it. That's a result of there being excess revenue in other hospitals that they're operating as part of this integrated health care system. I mean, Tower Health is a not-for-profit. Where is the money coming from that they're infusing into a hospital like Pottstown in the years that they aren't meeting any bogeys? Forget about compensation bogeys. They're just operating at a loss.
When Tower Health acquired the 5 community hospitals from the large publicly traded institution, it went out and did tax-exempt financing. Mm-hmm. It took out bonds. So Tower had resources that Pottstown didn't have. And Tower was able to underwrite the losses of Pottstown because it had those resources.
All right, go ahead and conclude if you would.
Thank you.
Oh, sorry.
In the event that this court decides to affirm the decision of the Commonwealth Court, what's the effect? What's the consequence?
The consequence, I think, is really significant. What the consequence would be is that in this highly competitive market where you have for-profit entities competing with not-for-profit entities, for-profit entities are going to have a massive advantage in recruiting employees because for-profit entities are going to be able to put these financial incentives out. They're going to be able to induce employees to leave not-for-profit companies, and it would have a very, very deleterious effect on the delivery of health care. Now, there's, of course, a lot of other purely public charities, not just hospitals. But what it would do is it would make the playing field very uneven. For-profit hospitals would be able to use all kinds of leverage that not-for-profits wouldn't. And the reason the court shouldn't affirm is because here, the acid test is the executive compensation at the end of the day was reasonable and within market. There wasn't a word uttered that contradicted that. What offended the Commonwealth Court is this notion that you'd have an incentive compensation plan that's based on finances. And I just think they got it wrong. They weren't faithful to the test in Wilson, and they overlooked the basic fact that the executives were not paid excessively. I just have one last point I'd like to make.
Can I ask a question real quick? What for-profit integrated health systems exist in Pennsylvania?
CHS, which is the entity that these 5 hospitals were purchased from. It's based out of Tennessee, I think.
Okay, I'm going to go again. What for-profit integrated health systems exist in Pennsylvania today?
I don't know if there's any based in Pennsylvania, but CHS owns a bunch of hospitals in Pennsylvania.
In Pennsylvania?
Yeah, they own 2 in Scranton. And I'm keenly aware of the difference between community hospitals that are owned by CHS, which are for-profit, and community hospitals that are owned by not-for-profits. It's dramatic.
Right.
And CHS still owns significant hospitals in Pennsylvania.
Thank you.
May I just add one last thing?
Yes, of course.
The incentive compensation plan was structured that if you hit the circuit breaker, the executives were eligible to earn more money. but it wasn't the top line money of the entity. What they had the ability to do was to get a percentage of their base salary. They earned more, they get salary added to their base. And the reason that's relevant is that there's two components of the incentive compensation. 60% of it had nothing to do with the financial performance of the company. What did it have
to do with patient care.
Had to do with the kind of stuff you and I care about: patient safety, patient satisfaction, employee retention, gradings and scores you get from regulators. That was just 60%. The other 40% was the possibility of a financial bonus based on the performance of the entity.
All right, I think we understand your argument. Thank you,
Thank
Mr.
you.
Breyer. Let's hear from Mr. Schauer.
May it please the court, opposing counsel, I apologize for being a bit delayed in getting back. It certainly wasn't intentional. I'd like to introduce here with me is Stephen Kalis, who is the solicitor at Pottstown School District, a partner of mine, and Gina Lombardo, who assisted on the brief in this case.
Welcome.
The analysis and argument suggested by Mr. Breyer essentially asked this court to overturn years of decisions from this court, starting with Hosp, moving through numerous decisions that analyze whether a charity is operating consistent with the requirements of the Constitution that it be a purely public charity on its head. The Hosp test, specifically the fifth prong, and that is the only prong that is at issue in this case, states that in order to meet the criteria for exemption of real estate, taxes and otherwise, an entity must be entirely free, it's a very full phrase, entirely free of private, there's a lot of cases that focus on executive compensation, not just the entity. That is misleading, I would suggest. There are a lot of cases that focus on executive compensation, private profit, and profit in a broader term than simply did we make more money this year than last year, but simply benefit to oneself. Am I better off because of what I'm doing than not?
Who's the self? There are no shareholders. Who's the self?
Executives.
Well, how is profit for the entity the same as compensation for the executives?
The profit used in the Hosp test goes to the advancement or benefit of the individual receiving, in this case, the monies, the executives.
Then
the executives.
Other than having a record developed, as was done here in the trial court, with experts testifying to what the market is paying for such people, are you suggesting that that be laid aside and that instead, in order to maintain nonprofit status, they must hire less qualified people and pay them half what people are making at other institutions? I don't understand the test you're advocating for. It's like an artificial leveling device that mandates that whatever the market, whatever willing buyers and sellers in the market are taking and getting, you have to just take some arbitrary portion of that and have a lower class hospital or a lower class of care because it looks greedy to you? I just don't understand your test.
It has, Justice Weck, that has nothing to do with me.
Well,
I'm merely reciting the test that was set forth by Hosp with respect to, is the entity operated entirely free of private profit motive? And for example, in Wilson, the analysis as to Wilson, the hospital's entitlement to exemption, the court said, yes, reasonable salaries were paid to the executives in Wilson, And there were no bonuses or fringe benefit such that the utilization inures to no individual. That's the language in Wilson. Wilson set forth a three-part test with respect to proper utilization of revenues, funds of a entity that wants to receive tax exemption. One, whether the utilization of the revenue is made with the expectation of a reasonable return or some non-monetary benefit. Whether utilization of the revenue ultimately supports or furthers the alienation, and counsel, we both have challenges on that word, nature of the charitable entity, but then most significantly, whether the utilization of the revenue inures directly or indirectly to any private individual related to the charitable entity or related organizations. Individual. The test, the cases that are cited in the briefs, many deal directly with individuals. Pinnacle Health, executive compensation was the issue, and it's the executive compensation. It's not, whether the organization was unfairly looking to generate a profit or a surplus.
Let me follow it up this way then. Suppose, as I think happened in this case, the record demonstrates that people, not compared to us, on state salaries, but compared to people out in that market getting hired to do these jobs, that's what they're paid these days, and they get bonuses, and in order to attract and recruit executives, that's what they need to do. What is the test that you want? What is the test we should apply to say whether this is too much or whether this smells like profit to us because the compensation seems unreasonable? What is there beyond some seat of the pants, jealousy on the part of courts that these folks out in the market are commanding this sort of money? It's like nailing Jello to the wall. I just have no sense of it. In other words, one more aspect of it. It can't just be that there's incentivization, because if there's no incentivization, presumably the best hospital executives are going to go where they're going to get incentivized. Can you respond?
Sure, I'm happy to. First of all, again, it's not my idea. Courts, for I believe it's now 39 years that the HUP test has been around, there are numerous cases that simply say the compensation paid to executives cannot be of a sort that is tied to or reflects individual profit from the operations and revenue of the entity.
So counsel, is what you're saying in this particular case that if the bonus was not tied to a compensation formula and was just given to him in a salary, it would have been fine?
Yes. Simply. No, it's that simple.
But counsel,
simple,
counsel, let me ask you this question, because this is a test you want us to apply not just to the mammoth nonprofits. It would presumably have to be applied to any nonprofit. So the rule you're asking for is you can't incentivize employees to run a solid nonprofit. That's your rule that you're asking for.
Again,
No, okay. Look, I understand you don't want to agree. You're arguing, that's the one you're arguing for. And my question is, let's say I have an upstart nonprofit. Let's say it's a soup kitchen. And I don't have any money to other than a really small amount to get this thing up and running. But I know this person who writes grants, and the person is a really good grant writer. And I go to that person, I was like, I can't pay you a salary, but I'll tell you what, I will give you 20% of everything you bring in as a grant writer. Is that a violation of the HUP test, in your view?
As the cases will say, everything turns on the overall facts and circumstances of the operation.
No, you can't. I'm not going to let you back, counsel. I'm not going to let you back off on that, because you just said in response to Justice, I don't know if it's Doherty or McCaffrey, the sun is in my eyes and they're both so handsome. I'm not going to. You just said to one of the justices at the other end of the table that yes, if it was just salary and there was no incentive whatsoever, it wouldn't violate HUP. Now you're telling me it depends on the facts and circumstances.
No, if this was a contractor, not an employee.
No, I'm saying it's an employee. I'm saying it's an employee. I can't pay you. I don't have the money as a nonprofit, but I am going to incentivize you. I am going to give you 20% of every dollar you bring in.
I would suggest that it's a very difficult question to answer. I mean,
Why is it difficult?
Because is that a direct from simply the monies that person brings in, or is this going to be taken from the overall revenues of the or surplus of the entity?
It's the only money that's coming in because we don't have any other money. We're asking you to go out and get grants. A lot of nonprofits operate purely on grants, by the way. So we're asking you to go out and get grants. I can't pay you. I am not a for-profit entity that can give you $60,000 a year or $30,000 a year, but I can give you a percentage of what you bring in. And if you're successful, I'm successful. If I'm successful, I can support my mission. But under what you are advocating for today, and based on your response to the question from the other end of the bench, that would be a violation of HUP.
In the real estate exemption area of the law, I would suggest it probably would be. They're paid on a percentage of the revenues that are received by the company. I was looking for the trial court when I did trial court in law school a long time ago. I remember I did answer a question with I think and was promptly told that it doesn't matter what you think, Randy, it's what the courts have said. So for my hesitation. But the case is, actually the case close is the Dunwoody case. In fact, the trial court, in an interesting insight into its reasoning, when it wrote its decision, the case of Phoebe Services had come down. That was a Commonwealth court case evaluating whether a entity that was seeking exemption from real estate as a charitable entity had been providing part of its profit, that individuals had been receiving improperly profit, if you will, or surplus from the entity. And in that case, to Justice McCaffrey's question, the incentives were 18 to 24% of the salary. In other words, the possible incentive that was available to the executive in that entity was 18 to 24% of the salary. And usually these incentives are based off of a salary, which is part of my problem, Your Honor, Justice Robson, with that question. And there the court did say, well, these incentives were not based on profit. They weren't based on income generated. In fact, there are cases that have even said that, Pinnacle Health, where it says, if the emphasis is on marketing or things that generate revenue today or maybe next year, if that's the basis for the incentive, that's a financial performance benefit that could well result in private profit inuring to the individual.
But to follow up on Justice Robson's, I'm not sure you answered his question.
Well, he said it wouldn't satisfy the HUP test.
I think you're indirectly you're telling him you would not grant that entity. You don't think our law would grant them a tax exemption, and you cited Dunwoody, which I think is just wrong. It's a Commonwealth court case 12 years ago, but the argument there by the court was that this retirement community was denied a charitable exemption in part because a, quote, substantial percentage of executive compensation was based upon annual performance. But that runs directly against, I think, the salient example Justice Brobson gave you of an entity that ought, under the HUP test, not be denied the tax exemption merely by arbitrary application of some ban on incentive-based compensation, right? Because if put it this way, if our cases are trying to, under HUP test, are trying to validate non-profits on the basis of this prong, no private profit motive. Why does that turn on whether the enterprise is being fostered with some incentivization of its executives? Let me give you this hypothetical, and then I'll shut up and let you answer. Let's say in your town there's a theater company, a nonprofit theater company, which is bankrupt. And there's an energetic young person who takes it over, and just like in Justice Brobson's example, there's no money in the bank there's no money in their piggy bank. But this person can go to some big foundations, etc. So you and the other board members tell him, go ahead and we'll give you 50%, 75% of your compensation in the first year based upon what you can bring in. And just 25% is this piddling salary we'll pay you. Why does that in and of itself defeat the fifth prong of HUP?
The fifth prong of HUP, Your Justice Wecht, you may disagree with it. In fact, that's the argument being presented by Pottstown Hospital. I can't see the court accepting it without essentially negating the fifth prong of HUP.
I'm just asking, what's the private profit motive there is what I guess what I'm saying. You have this nonprofit theater company. This guy or gal is going out there raising money to keep it afloat, keep their doors open, and you incentivize that person. Where's the private profit motive in the entity?
Well, the work being done, the revenues being received by the entity on some percentage in order to the direct benefit of that individual.
Counsel, doesn't it depend on how the revenue is used? In the two examples that we just got, I mean, these tests sort of tie together in one way, shape, or form, but I mean, if what's being promised at the end is 20% of what's left over after the expenses, otherwise operating expenses of the not-for-profit are covered, that to me seems to be a reasonable compensation, not necessarily directly tied to private profit motive. But if what happens is if this kid brings in $100,000 and a check is cut for $20,000 handed over to the kid, and the not-for-profit goes under that year because they're short by $20,000, then, I mean, I think that was entirely for the profit of an individual.
Yeah, typically the cases present as percentages of salary or potential extra earnings compared to salary based upon what criteria. Again, the test here is this organization truly a charitable organization, or in fact, is it using monies that should be going to the objects of charity, to those who should be receiving the charity? Instead, is it going to individuals who are working there? They incentivize, in ways other than simply to provide the charitable purpose of the entity.
So, counsel, I think that test has some salience for a sham nonprofit, meaning I start my own nonprofit and I solicit a whole bunch of contributions, and I don't
buy any soup.
And I don't buy any soup. Yes, I don't buy nor give any soup, and I pay myself a salary to the point where I'm not really accomplishing my charitable mission. The nonprofit's existence is solely to put money in my pocket. I think that example might be your problem. I think another example could be if there was evidence that the compensation structure was excessive in terms of the market, that it was not in line, that it was that could be another trigger. But the problem is you don't have any of that here. You didn't present any evidence below, any expert testimony below. I'm not an expert in executive compensation and nonprofit health systems. I don't integrated health systems. I don't know what is market and what isn't market. And from the entity's perspective, in the absence of sort of self-dealing, which we don't have here, and in the absence of a grossly excessive salary above market, what is a court to do in terms of the profit motive of this entity? Because profit is income minus expenses, and executive compensation is expenses. What are we supposed to do?
Justice Probson, what the court has always done, has done for 40 years under the Hosp test, is evaluate whether the basis of, in this instance under the fifth prong, the basis of the compensation of the executive, whether fair or not.
But no, counsel, look, I understand that you're just throwing their precedent back in our face, but if it was that simple, we wouldn't be here. The question that you have yet to answer, other than pointing us to our precedent, is how are we supposed to second guess the expert testimony and the fact finding of the trial court here in terms of this compensation and compensation structure being normal?
Sullivan-Cotter's tests are simply a comparison of amounts paid, bonuses, perks, etc., amongst similarly hospital systems of similar revenue and size. It says, well, X percentile make this much, it's statistics. You never go above 100%. Actually, in one of the years at issue, fiscal year 2019, 5 of the Tower Health executives received compensation around the 95th percentile, at the very top of the pay for, ostensibly, according to Sullivan-Cotter, similarly situated hospitals.
Well, you presented contrary evidence. Did you?
Yeah, I didn't need to. Frankly, I didn't need to. The record is full of just what was done.
Well, the trial court didn't. The trial court accepted it as credible. The trial court credited the expert testimony.
And the trial court was also going to find in the school district's favor, based upon the evidence that had been provided, until the Phoebe Services decision was decided. He said it in his opinion. It was surprising. It was refreshing. Trial court said, well, I was going to find in favor of the school district until the Commonwealth Court of Phoebe Services was decided by the Commonwealth Court. It was provided, the court got that after close of evidence, after briefing, and in its opinion, the court said, well, then I saw Phoebe Services, and in Phoebe Services, you know, the incentive was 18 to 24%, and I thought that might be controlling because it was found to be okay. However, the fact in Phoebe Services that the Commonwealth Court had found was none of the incentive compensation that was made available in Phoebe Services related to financial performance of the entity. It had more to do with hitting certain ratios, ensuring sort of being around going forward, accounting type stuff, but it wasn't based on the return or the revenue. Did they make a surplus or not surplus? So I kind of won the court case once, but then I lost it before I got that decision, and I didn't do it. It's the citizens of Pottstown. Come to the Commonwealth Court. Phoebe Services is a 2020 case. Commonwealth Court, and this was en banc in front of the Commonwealth Court at Phoebe Services, said, no, you've misinterpreted. You made an error of law on the basis of the facts found by the trial court. You know, because I suggest the HUP goes both to, is the incentive based upon revenues of the entity to the profit of the individuals, or is it just in an absolute amount? I mean, even the IRS taxes.
You said revenue, though. It's incentivization based on financial performance, right?
Correct.
So it's not revenue. It could be reducing expenses. You could have flat revenue, but you bring expenses down. It wasn't based on purely revenue.
It was based, the circuit breaker, which Judge Donahue, actually, they didn't get any, in this case, if we want to talk about what this case showed and the fact of no experts, I suggest to you, in the brief I addressed, it wasn't necessary. It wasn't necessary. But, back to your question, the focus was on, there's the circuit breaker applied, which if the operating margin of Tower Health was not achieved, all bonuses were off. The Executive Compensation Committee had the ability, I apologize for getting dry, the Executive Committee had the opportunity to award up to 50% of what the executives would have otherwise earned. And they did it. The record would show that they got bonuses during these deficit years.
That's your
especially
red
Tower
line.
Health.
Your red line is incentivizing based on financial performance. I guess the question I have is, if you want that to be a red line, if you think the law should be that that's a red line, then you seem to be insisting that nonprofits in this space, or in any space, I guess, be non-competitive. And that's not what our law requires. We have this 5-pronged test, so to comply with purely public charity, which is, a bit of a chimera. I mean, we struggle to see what that means, but this is what we've said it means. And now you're saying on top of these 5 prongs, if compensation is tied in any way to financial performance, that means you fail the 5th prong. And that seems to me to be a top-down mandate that insists on non-competitiveness in the nonprofit space. And I don't understand nonprofit to mean non-competitive, because that's also a synonym for failure.
Clint Matthews made whatever amount, and I'm not here to yell and holler about that. It's what it was. Let's say $1 million. Yes, if Tower Health, or Pottstown Hospital, Pottstown Hospital wanted to make sure it maintained its real estate tax exemption, it could have gone somewhere and said, wow, let's look for somebody qualified. And they didn't look for anybody. They just hired the people they had who had no experience in multi-system hospitals. I suggest that's certainly part of the explanation here. Again, the facts of the case are not supportive of the theories of the experts presented by them. But let's say you go to somebody and go, look, you're good. And you know what? We need somebody like you. Here's $900,000 salary. And here's some incentive based upon non-economic factors. No loss of exemption. No loss of exemption. None of the arguments from the nonprofits even suggest that if they have to pay real estate taxes, it's somehow going to put them out of business.
Well, that's not
never
the test.
said. Well, no,
people that are trying to get the hub test don't have to show, and it's a burden. They don't have to show that.
They don't, but that's the cry. If you read, I read the amicus briefs. If you listen to what is being said by Pottstown Hospital or Tower Health, like, oh my gosh, there we go. Suggest the taxes were approximately $1 million. Look at the numbers and revenues flowing through this system. That's the only effect of losing real estate exemption. They still have their sales and use tax. The difference with the real estate.
Again, you haven't answered Justice Weck's question. What is the proposition? You just gave this thing. They didn't have any evidence that they went outside and tried to attract somebody and everything like that. Let's say they did, and they couldn't find anybody that wouldn't do it if there wasn't a portion of the compensation tied to achieving a certain achieving a certain margin. Can they not hire anybody without losing their HUP test exam? HUP test?
Under that hypothetical, which has no basis in the record or the evidence, if that was the case, and they we just have to hire somebody and give them 20% of the surplus.
They could hire me. I won't demand that much money,
right.
but
could hire me, frankly.
But could they hire if the only executives that they have found that they feel have the experience and the expertise to help them run this integrated health system all say, look, everybody's doing this across the country. I want X number, and I want a bonus structure tied to operating margin.
If that happened,
right,
they would lose the real estate exemption. They wouldn't necessarily, and the real estate exemption, that's Constitution-based. The difference between the real estate exemption and sales and use tax, or the fee services case, dealt with a business tax that wasn't going to be assessed by the city of Allentown against charitable institutions. So if the fact that they may, because of not being entirely free of private profit motive, not embellishing it, that's the fifth prong of HUB, and entered into a compensation plan like that with the 20% of the gross revenues or something like that on top of their salary, up to 50% of their salary, what have you, that would disqualify them, from real estate exemption under the Constitution. It would not disqualify them from sales and use tax.
Okay,
Sales and use tax
I think we've got it. I'd like to wrap this up. Are there any other questions? All right, thank you.
Could I just very briefly?
You can conclude if you'd like, yes.
What I wanted to also illustrate is this, what happened in this case is not an accident. Please refer to the brief in the Commonwealth Court. Mr. Matthews and the Tower Health executives, they were scared. They didn't want to be bought. They didn't want the Philadelphia hospitals. They didn't want UPMC. So they're like, let's buy these CHS hospitals in this area. The person who asked for what will be the new payment structure for the executives at Tower Health, it was the senior executives asked Sullivan Cotter. It's in the record. I subpoenaed the records from Sullivan Cotter. They go, hey, what happens if we buy this multi-system hospital? What happens if the revenues go up? The revenues, the chairman of Tower Health testified under subpoena at the trial. We would have never been $1.2 billion if we hadn't bought these hospitals. And then just read about all the machinations, the increases in their salaries, the increases in the percentages they were making, totally constructed, I suggest to you, by the folks at Tower Health. And similarly, the question the court had was, what about Pottstown Hospital? There was a similar, incentive plan there. But as far as this sort of, how do we get these people? I would truly ask the justices to read what happened in this case, as far as determining whether, in fact, Pottstown Hospital, as operated by Tower Health, was really not have a significant element of private profit motive.
All right, we understand your argument. Thank you so much. Thank you both. Mr. Minner, would you call the next case? Well, this is an interesting case. In this case, Nathaniel Williams was charged with unsworn falsification to authorities, tampering with or fabricating physical evidence, tampering with public records or information, and obstructing the administration of law. Following a preliminary hearing, the trial court dismissed all of the charges, concluding that the Commonwealth did not present sufficient evidence to establish a prima facie case on any charge. The Superior Court affirmed. We granted review to determine whether a police interview, which was transcribed and then signed by the suspect, constitutes a quote-unquote written statement for purposes of establishing a prima facie case of unsworn falsification to authorities. We also granted review to determine whether the Commonwealth established a prima facie case with respect to any of the other charges against Williams, and whether, in affirming the dismissal of the charges, the Superior Court evaluated the evidence under the correct standard of review. Please proceed.
Thank you. Good afternoon, Your Honors. Andrew Greer on behalf of the Commonwealth. Here, while employed as a homicide detective, defendant facilitated his cousin's efforts to stalk the victim by sending her personal information after obtaining it through searches of restricted police databases. He lied about doing so in a signed statement to an internal affairs investigator. Then he altered an official homicide file to bolster his lie, and then he falsely...
Those were the allegations, yes.
Yes. So... maybe not to split hairs on the first question, but I mean, written statement, this was 6, pieces of paper like my outline here. It was written. It was a statement. I mean, as far as this court determined, relatively recently, a statement is a representation. His answers are representations, so it meets written statement.
It was a transcription. It was a transcription of an oral interview, correct?
Yes. So what I'm saying is this is a writing, and it contains statements that come from this defendant. So again, maybe I'm splitting hairs, but that's why in the briefing I focused on the word make. The verb does participating in this oral interview, being the source of all of the information contained in this writing, does that constitute making the statement? And
I thought it's the initialing of the. Am I wrong?
He signed it. He signed it.
Yes,
initially.
in substantively providing that content, and then in addition, not just initialing, but signing each of the 6 pages, and the last page, is the one that says something to the effect of, as to the best of my knowledge, all of these contents are accurate.
That makes a big difference. I mean, if it was just a transcription of an oral interview without any acknowledgement or signing by the suspect, I think that would be very different.
Well, yeah, you sort of de-emphasized, or you emphasized the statement itself, but isn't for the word making under the unsworn falsification offense, the emphasis is on the signing, isn't it?
Yes, sorry, I was trying to winnow away the things that I thought were non-issues. I agree. The making is the signing. But I also want to clarify that this isn't signing a pre-filled out form or, checking I agree to the terms and conditions every time an app updates. This is the statements contained within that writing that was signed. It's only information that came from defendant, the person who signed it. So this isn't, pulling one over on somebody going, oh, you didn't read closely enough this, form. Like I filled out a passport application recently that was like 20 pages. I checked a lot of boxes. I affirmed that the contents were true, but I did not fill any of that out. I did not respond to open-ended questions and fill in that information. So the short answer is he made a written statement and is not absolved from criminal liability by the fact that somebody else was typing the keys. Unless your honors have more questions about that, that is really my argument on that, as well as because, if your honors agree that doing so was making a written statement and therefore makes out the crime of unsworn falsification, that crime is any unlawful act that meets that other element for obstructing the administration of law. So. Then when he was offered the opportunity to go back and review each of those pages, and again, not just sign at the end, but each of the 6 pages and sign his name, that was his opportunity to correct them. And of the many police interviews I've seen, it's not all the time, but sometimes there are corrections to a word here or there.
Well, that last point is very interesting because apart from Chirpy's, I don't know what cases are out there, and that's not even police interview scenario. I'm surprised that we don't see reported cases dealing with this because the detectives are always asking people to initial the bottom. I'm wondering. I guess these cases aren't brought.
Yeah, excuse me. I don't have a reason as to why those cases might not have been brought, but I would just say I too was surprised that Chirpy's was the closest case on point, and it, I feel like frankly involved less substance than what was present here.
Commonwealth. Your brief, you argued 4910-2, but I reviewed your document statement, and it seems you only charged him with 4910-1.
Yeah. I argued subsection 2. In addition, I will admit it was an embarrassing mistake having inherited from a previous attorney and seen what was argued in refile and then not being able to find the criminal complaint on the court website. Significantly, though, for both 4910-1 and 4911-1 or 2, either way, the common relevant word is alter. And here the evidence did show that this defendant made a false alteration, whether it also meets a definition of presented to or what have you. So the error in the in the Superior Court, specifically here. Oh, yes. Yes. For that one specific statement, I'm still going to argue yes, and that adding maybe to any answer. I'm not sure, maybe a year or more, when we look at the evidence that shows within the past 12 weeks they've exchanged hundreds of text messages, and then if we're also going to split hairs about whether that's have you spoken to, they've also exchanged 20 or more phone calls, and then if we're going to say that just because they were under 2 minutes it may have gone to voicemail, that all 20-some calls went to voicemail, we're getting very, very unlikely that that is what actually happened. And he must know, like any fact at issue, intent and knowledge can be inferred from circumstantial evidence, which is part of what I argue that the Superior Court seemed to kind of ignore. And here the circumstantial evidence shows that he must have known that within the past 12 weeks he had all these communications with his cousin Edwin. But in addition, that's not the only statement. He used 3 separate restricted access systems. For each of those, he was asked, did you look up this person's information in them? Yes or no? He said yes. And did you do it for business or personal? Each one of those, he said business. Those were more false statements. So he lied about the nature, frequency, of communications with his cousin Edwin.
Were they false statements, or are you alleging they're false statements and you want to get past the prima facie?
Then I'll say at a prima facie level, they're.
Well, yeah, I think your case is extremely circumstantial. It's.
I'll say it relies on many circumstantial. Sorry.
Right. No. Yeah, but you're not. You're going to have to prove that the statements were false.
Correct.
And you're asking at the prima facie stage, you're just saying that the Superior Court put us too high of a burden of proof at the prima facie. We should be able to draw reasonable inferences that, for example, I pulled the homicide file and there was only one file, and the next day I find out that there's a second file, and I should assume or presume for the Commonwealth should get a reasonable inference that the second file didn't exist until he produced it, without any evidence yet that that is true.
Without any short answer, yes.
Right.
So I think the closest more and to further explain, as is often the case with conspiracy, we're never going to find a conspirator admitting I agreed with this person, or even like a video of a secret agreement. As the law recognizes, it's shown by your actions and words whether there was an agreement. So similarly here, it is taking all of these facts together. Sorry, I seem to have lost my place on that point. But the short answer is yes, I think these are reasonable inferences. Looking at the totality of the evidence, and I guess the only reason I wavered is it's not just the mere fact that one extra file was discovered after the other. The really, really significant point here is the actual content of these files. So according to defendant, Teresa Williams is a person of interest in an official investigation. I'm just doing my job, looking at all leads. So I look at all the persons of interest.
Just coincidental that my cousin was stalking her.
Correct, and not just that, now that I know that there's an official investigation of my actions, now that I know that my records have been pulled and they can tell if I look at these databases, and I've directed them to one file that I know doesn't have any of this information in it, all of a sudden I come up with a handwritten piece of paper that only has untraceable, publicly available information, whereas all the other persons of interest and suspect actually had their printouts from these restricted databases. The reasonable inference is he knows he's under investigation, and that if he goes back into these, the NCIS and JNet, there will be a record of him doing so. So he wrote it down because it'd be untraceable. The actual information in his handwriting could all be obtained from the content of the questions he was asked the previous day, and he was given a copy of his statement.
Okay, we get it. Do you want to address the standard of review?
Just very briefly, it comes down to two big groups: giving defense favorable inferences and disregarding the Commonwealth favorable inferences. I think I've gone into how there's a lot more going on in the Commonwealth's favor than I think was addressed in the majority opinion below. And just in terms of defense favorable inferences, the court suggested that, seemed to take it as fact that he was including this information about Ms. Williams as part of his official role as an investigator, but kind of as I already explained.
And Judge Olson made all that very clear, including your initial arguments on the first issue in her dissent.
Yes. So if your honors have no other questions, I would just direct you back to my brief on any remaining questions.
Thank you. Your opponent, Mr. Siegel.
Good afternoon. May it please the court, Jacob Siegel on behalf of Nathaniel Williams. As my colleague indicated, we're here for 4 charges, and the question is whether or not a prima facie case was made at the lower court to show or establish the elements required, more likely than not, for those charges. It's our position that the evidence presented at the lower court did not meet the threshold level at a preliminary hearing, more likely than not, to hold the matter for court. The evidence that the district attorney's office presented at trial was insufficient to make out the charges that are before the court today and that were before the 2 lower courts, the 2 independent Philadelphia judges, the Superior Court panel, and then the Superior Court en banc. The evidence that was presented and that's on the record simply does not make out the charges before the court today. Specifically, with respect to 4911, tampering with public records, it's charged as a felony of the 2nd degree. As the en banc court indicated in their opinion, there's an element there, it's Commonwealth v. Kitchen, that requires, if it's a felony of the 2nd degree, there's an intent to defraud. There's an intent to defraud or injure, which requires a demonstration of a loss, a pecuniary property loss of some sort. That has not been established here. That was not established at the lower court. That charge, the burden that the Commonwealth has, as more likely than not, it's not beyond a reasonable doubt, does exist at the lower court, and that burden was not met with the evidence that was presented at the lower court with respect to the charge of 4911 as a felony of the 2nd degree. There are different gradations of that charge, but the charge that the Commonwealth elected to pursue was a felony of the 2nd degree, which has those requirements which were not shown at the lower court. With respect to 4904, unsworn falsification to authorities, I respectfully disagree with opposing counsel with respect to what constitutes a written statement. As Justice Wecht pointed out, the one case that's on point, or the one case that seems to even a little bit address this issue is Chirpy's, and there's not a lot of jurisprudence out there on this point. And the question of whether or not it's a written statement as required by the statute, not a written statement generally, we submit that it is not. And the reason for that—
Common sense definition, are you contending that a common sense definition of a written statement is different than what the statute requires?
I am submitting that the statute itself does not allow for an oral statement which is subsequently affirmed with a signature.
How do you argue against counsel's argument with regard to making? Did your client not participate in the making of the statement for which was transcribed, reviewed, and signed and verified by your guy?
So the statute is narrowly constructed, 4904, to require the making of a false statement, as the court pointed out. It's our position that there are other places where the legislature has stated making a written or oral statement, where they differentiate between the two. Now here, the question is this a written statement? Is that signature a written statement, as would be required to meet the burden here? And it's our position that it does not suffice to establish a written statement as is required by the statute.
So you're articulating that the accused has to write his or her own statement?
The accused has to write something that is false in order for them to be appropriately charged with this penalty.
So if an individual is illiterate, unable to read and or write, then what?
then the charge of unsworn falsification would be an apposite, is my position, because the written false statement language in the statute is clear. Had the legislature wished to include that in there, they would have, as they have done elsewhere, as was in our brief. There are places where the legislature says prong 1 makes a false written statement. Prong 2 makes a false oral statement. That differentiation does not exist here in 4904.
Your definition of written, isn't that somewhat absurd to say individuals who can claim they cannot read or write should not be charged with the crime when others who are blessed with an education can?
So under that hypothetical, if they're unable to read or write, if they're unable to write, then to charge them with making a false written statement seems like it would be difficult to prove.
Can I follow up on Justice Dougherty's question? Is a signature a writing?
Yes.
And did your client sign here?
Yes.
Yeah. So the detective presented him with a version, at least, of what the defendant allegedly said, right?
An oral, yeah, a transcription of...
And then he wrote his signature. He wrote it.
Correct.
Which is a making a writing?
Of his signature.
Mm-hmm. And so you're saying that that doesn't constitute a written, if it's false, a written false statement.
And that's the point. The description that you just gave, his signature is the written portion of that. So the question, as was addressed in the en banc opinion in our brief, is that signature itself sufficient to show a false written statement? It's not, is the signature in conjunction with the document that it coincides with? Is that signature itself sufficient per the statute as it is written to show a false written statement?
Let me ask you, should we, I don't know the answer to this. Should we, in deciding that issue, should we try to imagine what the purpose, what the detective, I don't mean this particular detective's purpose generally in having subjects sign to adopt their statements, what the purpose of that is?
So I would submit that the purpose there, having been a former DA for some years, when there is a later, when the person who gives that statement later recants or goes back on that statement, to then be able to confront them with it and their signature, not that they wrote that statement, that is, that as the Brady Lively procedure goes.
Prior and consistent statement?
Correct.
So it's a validation. I'm not sure why that's not a prima facie case for unsworn falsification.
Because the statement here, so it's as you said initially, it's the signature itself that's what he wrote. That's the written portion of this. And so the question then becomes, is his signature, him writing that signature, is that a statement such that it is false within the purview of the statute? And the statute is narrowly written such that it only includes a false written statement. It doesn't go beyond that adopted, affirmed, oral statement.
Okay, we understand your argument. Any other questions? Thank you both very much.
Thank you.
Mr. Warner.